Is it a hearing matter? Oh, give the number, please. Sudeshna, extension of interim order, Calcutta. No. It's still today you're saying, the interim order, it'll appear tomorrow. One by one, please. Yes. Give the numbers.
Belongs to tribal community and his land is obviously tribal land. Now, my lord, the Mal municipality is using the petitioner's land, my lord, without consent of the petitioner by inviting tender and generating revenue. So, my lord, because of the violations of the right to property, I approached before this honorable court, and there is a directions by the honorable court not to, my lord, use that land, my lord, till disposal of the instant repetition, and there is a direction for exchange of affidavits. Now, my lord, affidavit has not been filed by the Mal municipality as yet, but what they have done, my lord, they have, my lord, started, my lord, using the land by conducting Rother Mela, my lord, without, in violations, gross violations of the order.
Give the number, please. Give the number.
My lord, new motion for new motion, my lord.
New motion, give
New motion.
List getting longer.
Motion.
Yes.
And one more motion.
Yes.
Correct, sir.
Yes. Give the number.
Motion or MACC.
MACC, this code doesn't have determination, I think. Huh?
This code, Rashid.
That's it.
If Rashid release, then it will go to code number 3. Otherwise, this code.
MACC is group 6, isn't it? MACC?
Civil appellate jurisdiction.
Huh? Oh, it's a civil matter.
Civil appellate jurisdiction.
Your Lordship,
Yes. Give the number.
Your Lordship, may I be,
If this is the list of motions, I do not know how hearing matters will be taken up.
My lord, may I be
permitted, Your Lordship?
matter under extreme compulsion?
Please wait, please wait.
Your Lordship, may I be permitted to mention, Your Lordship, in this few matters, Your Lordship, the affidavit direction was given. However, the affidavit has not yet been filed, Your Lordship.
Why
Necessary
don't you
order.
wait for some time where affidavit directions are there? You are enjoying an interim order, right?
No, Your Lordship, no interim order is there, Your Lordship. And in one matter, Your Lordship, the assessment order has already been passed with regard to
Please
the
do
revenue
not
matters.
mention any more hearing matters. Let me deal with the motions.
My lord,
No.
my lord, I'm mentioning a matter under extreme urgency, my lord.
Arbitration proceeding also this court? No.
My lord, first court.
Yes.
First court.
First court is dealing with arbitration matters.
Yeah.
First court deals with these matters, I think. Oh, give them.
Your Lordship.
My lord, I'm seeking leave to mention him.
14th March 2024. My lord, there has been a packaging application filed last year, but on the last day on 20.
There must have been a direction for affidavits also. Complete?
And my lord, they were willing to get the matter heard together with the application with the petition. But kindly one intelligence I'm seeking as traveling from Kolkata, but kindly fix it tomorrow so that I can appear physically.
With the list of, I understand, madam, but with the list of motions that I'm finding, I do not know when I'll be able to take up hearing matters. And I'll allow you to move virtually if that's required, right? Give the number. I do not know whether it will appear tomorrow. You can give the number.
My lord, may I be permitted to mention?
8 matters. Only 8. Very well. Give the number.
Your Lordship,
My lord, may I be permitted to mention a matter, my lord?
That is only part of the college. Last day, on last occasion, before the Honorable Justice, hearing was conducted, one interim order passed, and liberty was given to us to mention this matter for further hearing. Now that the exams are coming, if this hearing matter is not taken up, will not be able to suffer here.
This is group 2.
This is group 9 here.
How is it group nine?
Exception, extraneous matter.
Give the number.
Your
May I
lordship,
be
that was
permitted to
mentioned
mention an urgent matter, my
in
lord?
the new matter, your lordship, the exchange of affidavits were completed, but in between the matter was pending before the High Court, your lordship, the assessment order was passed. Thereafter, we have filed a CAN application. In that CAN application, they have sought time to file the affidavit. Only 1 week time was given, your lordship, and that has expired, your lordship.
Affidavits have not been exchanged.
Not
as
yet, not
Give
been
the
exchanged.
number.
My lord, may I be permitted to mention a matter in urgency, my lord, because my lord, we have challenged an order of assessment made by the DM, my lord. My lord, that last date of payment is on 3rd. We have assailed that order, my lord. Affidavits have been exchanged. And my lord, there is a very short point of law which is already decided by the Honorable Supreme Court, my lord. If my lord takes this up matter, it won't take more than 2 minutes, my lord.
See to give
My
the
lord, my,
number. I do not know when this.
My lord,
2
because
minutes
3rd is the
will,
last date that has been given for me to make
you
the
have
payment.
Interim order.
No, my lord, there is no interim order, my lord. That is the difficulty, my
Give
lord.
the number.
Affidavits have been exchanged
Give the number.
pursuant to the direction of the Honorable Division Bench, my lord.
Yes. Why don't you wait for some time? Where affidavits are not ready, please do not mention.
I can say is that the perishable are with the state, your lordship, everything has already been.
Give the number.
My lord, may I permit to?
Hearing matters, I really do not know.
My lord,
Give the number. Give the numbers.
My lord,
Give the number. Let me see.
my lord, this is an urgent matter. This is an urgent matter regarding the appointment of a,
You're appearing in person?
yes. Please, fix it tomorrow or day after tomorrow.
That I cannot assure. Give the number, please. This
my
is
lord,
group
may I be
2.
permitted to mention?
Group 2 or service matter?
Service matter.
Service matter, this court is not dealing.
Appointment,
Service matter, appointment includes service.
Ah.
It's under service.
no, appointment.
This court is not dealing. Justice Shamuntar court.
Lordship, maybe. Lordship,
Please
maybe.
find out. This court is not dealing with service matters.
Court number 3. Court number 3. This is matter where amicable settlement.
My lordship, my lordship, may I permit to
My lord,
mention
may I
matter, my
permit to
lordship?
mention?
Have you
Matter-
served the other side? Please file upon service, then I can keep it tomorrow.
Lordship, I'll serve.
No. Please inform the other side so that I can fix
My
it.
lord, may I be permitted to mention matter, my lord? This is a matter relating to challenging the order of the maintenance tribunal, my lord. There was a direction to filing the affidavit in opposition, my lord. They did not file it till date, my lord. The direction was passed in the month of January, my lord. My lord,
Give the
kindly.
number, let me see. Give the number.
And my lord, there is another application. There is another mention, actually, my lord. The matter relating to the demolition of the illegal construction, my lord. And my lord, there the matter also been heard on the month of April, my lord, and thereafter could not be taken up because due to the reason of the service could not been
Hearing
effected
matter.
properly. No,
At the
that's
motion
under the
stage.
motion.
Give the number.
My lord, I
Much
have
obliged.
the honorable court check the application and the petitioner claim of the honorable.
For release, for release. You want to withdraw? Very well. To be mentioned.
I have a mentioning in regard of the national highway.
You may mention a matter for inclusion in the list. I'm the intervener of the writ petition. It's a CRAN application.
Have you served
Lordship,
the parties?
Lordship,
Give the number, please.
grateful, Lordship.
Yes, call the list, please.
My lordship, may I permit to mention a matter, my lordship? My
Yes,
lordship,
yes.
my lordship, I have one writ matter, my lordship. It is long pending matter, my lordship. This matter.
Hearing matter.
Yes, my lordship. Matter is of WBSTCL electricity illegal disconnection, my lordship.
Give the number,
this
please.
disconnection-
Give the number, please.
My
Yes, any
lordship,
other mentioning?
my lordship, I can give in the chat box, my lordship.
Shudishna, chat box a number.
Yes,
Mention.
yes, sir.
Yes, call the list, please.
Item number 1, Mr. Shandip Chararia will be appearing in this matter due to some personal difficulty. He's can't able to come court, lordship. Kindly fix it on 8, lordship. Huh? No, Mr. Choraria will be appearing in this matter. He's some personal
Appealing for
difficulty.
the state response.
Lordship, he will physically come and do the matter, lordship. On 8, lordship.
Very well.
Lordship,
Eight.
I'm great.
Learned counsel for the petitioner seeks accommodation. And let the matter appear under the same heading on 8th July 2025. Next.
Item 2 also, Lordship.
Same order.
He is at.
Next.
इनकम टैक्स का मैटर है आप लोग अपेयर करेगा यदि सर्विस होगा तो
Your Lordship,
Lordship, in item
Led by
number
Mr.
3, I am
Deputy.
seeking for 2 days accommodation, Lordship, as the report yet not come, Lordship. This is
If all
regarding
the
police in
matters
action,
take
Lordship.
accommodation, then what will happen?
Your Lordship, I am appearing in item number 3, Your Lordship.
For
Lordship,
the
this
petitioner?
is a matter. Petitioners, yes, Your Lordship. Lordship, I'll drag your attention on small point, Your Lordship.
Yes.
In the petition, Lordship, if you come to the FIR of the main matter, which is in page number 20, Your Lordship.
Yes.
Case has been registered against Joseph Kati, Subha Kati, Asit Kati, and Rikas Pradhan
Yes.
of taking money, creating criminal breach of trust, and cheating. But most surprisingly, the money was taken by only Joseph Kati. In his account, Subha Kati, Asit Kati, they are the family members, wife. Against them, how the proceeding is been done, no one knows. Your Lordship, if you see into this, they have no link into the matter, Your Lordship. And
You need
for
to go
the
for
FIR
motion
being,
in that case.
Your Lordship,
So
they are
he is checking for
disturbing.
this.
We are not even getting the certified copy from the court, Your Lordship. We are out of our houses, Your Lordship. If a protection is been given for some days, we can go and do the needful, Your Lordship. The wife and the family members, they are not at all involved in this matter, Your Lordship. The money is taken by Joseph Kati. It's a matter of cheating and criminal breach of trust. The people who
Yes,
have
so in
not
that
taken the money.
case, the BNSS will help you. You need to go for a quashing, isn't it?
Yes, Your
Earlier
Lordship. If you give us
482.
some time, we will go, Your Lordship. If some time is given, at least for 10 days, we will
What are you
comply with
asking
the
for
same.
in the writ petition?
In the writ petition, the female member Subakati was been threatened and is been forced to transfer the property by the complainant who are influential people. They are not even allowed to come to the police station, Your Lordship. I've
The
even
report
given
was
in
called for?
annexure page
Lordship,
number
his
17.
name was already reflected in the complaint, Lordship. If Lordship come to the complaint.
Yes, Your Lordship, but she has no involvement in the
Lordship?
case. Subakati. You check the FIR, Your Lordship. Money cheated done by Joseph Kati, the female member, and
Lordship,
Asit Kati. They
investigation
have
is
no
going
involvement
on.
in the case.
Subha Kati is the wife of Joseph.
But Your Lordship, she is the wife. She has no involvement. It is
mentioned
done
Your-
just to.
Your grievance can be solved only by a quashing application, sir, not in a writ petition. I'm sorry. You can
Oblige, Your
withdraw
Lordship,
this,
but
you can
if,
file an appropriate application.
of course,
How
we
will the
will do.
writ
If
court help
10
you?
days or a week time is given, we will do the needful. At least a week time, because we are not able to go to the court and take the certified copy also, Your Lordship. This is the problem, Your Lordship.
Seek
Just
leave
a
to
week.
file without a certified copy. State these facts before the appropriate court. Seek leave to file without a certified copy. I do not understand how the writ court will help you.
If because it is after all inaction, a wrong action has been taken against
This
me,
is
Your
not
Lordship. If you
inaction, sir.
appreciate this.
This is, I'm sorry, sir, this is not inaction. The action has been rightly taken on the basis of the complaint and the FIR, formal FIR.
My Lord, the FIR was just
remedy
to make
lies
to force
before-
my family members, Your
The
Lordship.
state wants to come back with a report. If you want to waste more time, you can. You are at liberty. But I think the better solution.
But till the
will be-
report come, Your Lordship, may I request a humble prayer?
Without a
Till the
report, I'll
come,
not grant any order, sir, in this writ petition.
Till
Please.
the time, if no coercive action is also given,
Lordship,
then also
no,
it will do,
no,
Your
not at
Lordship.
all. Why?
Lordship,
Your
in the
name
FIR,
in
it
the
is
FIR.
clearly mentioned, Lordship. Name of the writ petition, it is
Yes,
clearly
I've seen
mentioned.
this. I've seen your name in the
Your
FIR.
Lordship, everyone can file any FIR against anyone, but there has to be some
Yes,
grounds.
so
Your
where is
Lordship.
the remedy, sir? We are only spending time unnecessarily. Where is the remedy? The remedy is not before the writ court.
Can I get a week time, Your Lordship? Again, I'm making a humble prayer so that I
A
can go
week's
to the
time
court,
for
take
the
out the
report to
certified
come,
copy.
no other order will be passed. If you're agreeable, let the report come.
Let the report come, Your Lordship, then.
Learned counsel for the petitioners submits that the petitioners have been falsely implicated in the criminal case and are being regularly harassed by the police authorities. Paragraph, learned counsel for the state seeks to submit a report in this regard. Paragraph, 7 days, madam?
Lordship, 2 days.
2 days?
Yes, Lordship.
Very well. Let the matter appear under the same heading on 3rd July,
Lordship.
3rd July.
Obliged, Your Lordship.
Next,
Is it?
Services not even completed.
4 to? Can you come at next week?
Next week.
What are the matters about? What, you're not aware. Since service upon the,
My lord, I'm for this state.
there are
In 8. No, 7, my lord.
4?
4, no. 4 to 8.
Since service upon the opposite parties is not complete, comma, let the matter stand over till next Monday. Till next Monday is 7th. I think 7th July. 4 to 8.
Yes, ma'am.
4 to 8.
7, my lord, let state appearances.
In 7th,
Yes, my lord.
let me see. 7th again. There are other opposite parties
Yes, madam.
besides the state.
Yes.
My lord, answering respondent is state only.
We
So
have
he's-
state, but not
He's appearing.
state.
State is represented. So you can, yes.
Other parties, lordship.
Who are the other parties in this matter besides the state? All of it is state. Then he's appearing. He's representing all the opposite parties. He should be ready in this matter.
Praying for not today, I just take the instruction, I'll do.
Yes, my lord, because in this matter, they have taking, my lord, employment of for the Anganwadi workers, my lord. So I have informed the brief was handed over to me yesterday night, and I informed the concerned department. My lord, they are going through the documents, my lord. We need a week time. So if a week is granted, my lord, in this
Very
matter,
well, very well.
item number 7.
You want to come back with a report?
Yes, my lord. Next Monday, my lord, if
7 order করুন. Learned Counsel for the state seeks to submit a report in this matter. Paragraph, let the matter appear under the same heading on 7th, next Monday?
next Monday, my lord.
Great. 7th. All the other matters will also appear on Monday, right?
Deeply obliged.
4, 5, 6 or 8. Same order. 7 and 8. Next. Yes, 9. You're appearing. 9, no one. No one in 9. Next circuit. None appears for the petitioner. No accommodation is sought. Let the matter be placed before the next available circuit bench. Next. Yes. Yes. Have you served?
Relating matter.
A revenue matter.
Revenue, whatever matter is very simple. Only the adjudication order was passed. It was supposed to be uploaded in the portal. Unless it is uploaded in the portal, I can file the appeal. So
A direction for uploading.
uploading.
Who is appearing?
I have served upon all of them.
State?
I've
Who is appearing for the
I've
state?
Party, the concerned department.
All state authorities?
All state authorities. The distinct commission, not CGST, central. CGST, central, all central. I've served upon all of them. Mr. Rotangoni appears.
Not today.
Not today.
Will you please inform him
I'll
so
tell
that I can deal with it? It's a very short matter, can be
Very
dealt with. Chudishna, Calcutta, not today. Next.
Lordship, I'm for
Yes.
petitioner, service is already completed.
Lordship, I am for the Jalpaiguri municipality. I have 2 days time. Lordship. For instruction, the Lordship.
Day after tomorrow?
Thursday, your Lordship.
Thursday.
As your lordship.
Affidavit of service. Learned Counsel for the opposite parties seeks accommodation. Have you served the private opposite party?
Yeah.
You are appearing? Learned Counsel for Opposite party numbers 1 to 5 seeks accommodation. Paragraph, let the matter appear under the same heading on Thursday's 3rd July. Next.
I've served upon the, answering respondent is the Kalimpong municipality.
Served?
Yes, I've served. You are appealing to, yes.
Yes. You are for?
No,
Oh, the municipality, Lordship, it is regarding the pension benefits.
Pension
Lordship, we have not
benefits.
got, Lordship. There was a similar matter, Lordship, which was kept on 13/6/25, Lordship, and the court had given a court 4 weeks time for Lordship to reply. So kindly keep it up to 4 weeks.
no. You kindly come to page number 13, Lordship. What reply?
And similar matter.
No. Kindly come to
Page number?
Page number 13, this is the first annexure,
1313.
1-3.
Yes, what is the matter about?
Lordship, my husband, the husband of the petitioner, he retired from his service. He was getting his pensionary benefits, all of a sudden it stopped. Now, there was no disciplinary proceedings initiated, there was no reason shown that why it was stopped. I filed a writ petition on the earlier occasion, kindly come to page number 14 on this is the earlier round of litigation. This WPS 99 of 2025. And when order dated the 22nd January 2025, already order was passed. If your Lordship kindly comes to page number 15.
This
Now,
is the same petitioner.
same petitioner. Page 15, the second paragraph. In view of the above, the respondent number 6 is directed to consider the records and after careful carrying out necessary formalities to release all the employment benefits of the husband of the petitioner in favor, including the family. Neither have received the family pension nor the gratuity amount. If your Lordship kindly comes to annex P30, annex 30, page number 30, annex P1.
But you say that pension had started, then it stopped. That is what you said, isn't it?
Yes, only 1 month pension was given, thereafter it automatically stopped.
Lordship, yeah, all staffs of Calcutta municipality, they have not received the payment, Lordship, pension benefits and gratuity payment. Gratuity payments, Lordship.
Like gratuity has been.
Lordship, kindly pardon me, Lordship, I'm handing over my phone because I didn't see the print of copy.
No, that's the other matter you say.
But
let us deal with them separately. That matter is not appearing in the list, right?
Municipality needs to release the funds, Lordship.
So why aren't you releasing it now, by now, sir?
Kindly give us 4 weeks time, Lordship.
No. For what will you file? There is nothing to file. Come back with the report on the next date. You don't need an affidavit in this matter. Please come back with the report on the next
Yes,
day. I
I
can deal
am
with the matter.
entitled to.
There is already an order of the court. If you
Yes.
find her ineligible, you have to tell us so.
They did not take this order for consideration. They only one day I went to for submitting serving the order, copy
Please
of the
take
order.
necessary instructions or rather give necessary instructions so that this order is complied with. Otherwise, I need to call all of them to court. Let me tell you. This is not done. Or people suffering for such a long time.
My gratuity.
Her husband expired in 2021. We are in 25.
Kindly pass an order, Lordship, regarding the report, while submitting the one day.
Affidavit of service. Learned counsel for the petitioner submits that despite an order passed by this court on 22nd January 2025 in WPA 99 of 2025, directing the opposite parties to release all employment benefits of the husband of the petitioner, including family pension and gratuity, along with interest to the tune of ₹6% per annum upon consideration of the relevant records and carrying out necessary formalities, the order has not been complied with till date. Stop. The petitioner received family pension only for a month.
Lordship?
Only for a month.
Yes, I have instruction only for 1 month.
We stopped thereafter. Paragraph, learned counsel for the state seeks to submit a report in this regard. Learned counsel for the municipality. Seeks to submit a report in this regard. Paragraph, let the matter appear under the same heading Friday.
Monday.
Very well, Monday, but it should be Monday. 7th. Why deprive your employees?
Lordship, may I request Lordship, in item number 9, Lordship, I was in court number 2 in Lakes, Lordship, your Lordship had fixed at the next circuit,
Yes.
Lordship. Lordship, kindly, Lordship, the matter is very urgent, Lordship.
Not today.
Grateful, Lordship.
Someone
Yeah,
should be there to.
Yes, Lordship, but
Wait.
Lordship.
Next.
Next one also, Lordship, what is I'm appealing for the petitioner.
Yes.
Similar type of matter. He was also employee of the
You're
Calcutta municipality. Now, in this case, Lordship, the order was passed on 14/5/2024.
Here the petitioner himself was the employee, right?
Yes, yes. I communicated the order to the Kalimpong municipality. Now, thereafter, I have given several letters. Neither they have revised my PPO. I am supposed to get the pension in terms of ROPA 2019 because the government notification says that pensioners.
You ought to have come up in a contempt. There's a time frame here, 2 weeks from the date of order. So the municipality is lucky that he has not come up in a contempt.
Yes.
Please comply by the next date. Otherwise, I'll request you to file a contempt application in this circuit.
Lordship.
Learned Counsel for the petitioner submits that despite an order of this court dated 14th May 2025, passed in WPA 855 of 2024, the opposite parties have not released the pension of the petitioner along with the arrears.
They have paid me some amount, but they are not paying it regularly. I am liable, entitled to get monthly pension every month, but they are
Is
not.
not paying the monthly, if the opposite parties have not, opposite parties are not paying the monthly pension of the petitioner regularly.
In terms of ROPA 2009.
Regularly in terms of ROPA
ROPA
2019.
2009.
ROPA 2019. Paragraph, Learned Counsel for the municipality seeks to submit a report in this regard. Paragraph, let the matter appear under the same heading on 7 July, same date.
Good. Lordship, my affidavit also.
Show the affidavit of service. Next.
I am appealing for the private respondents. Have your lordship? My lord, may I be, my lord,
Yes.
I am appearing for the
He's
private
appearing.
respondents. Yes, my lord, I am appearing for the private respondents. My lord,
Service
eight-
is complete.
Yes, all these, my lord, we have already, my lord, 8, 9, 8, 9, 10 and 11, so I am appealing.
Oh, you're
But,
appearing for
what-
the private opposite
all
parties.
the private parties.
What about the
My lord,
state?
so far as my lord, the issue is concerned, but that the same
Mr.
allegation.
Mukherjee, Mr. Mukherjee, state has not been served.
My lord, that
So I'll fix
apart,
a
that
date.
apart. My lord, kindly,
Oh, you are
kindly,
We are ready.
Yes.
Why? Everyone is served.
My lord,
We should be
my lord.
ready.
Yes, my lord, the allegations
ready.
against myself in a similar writ petition which is appearing, my lord, which is not appearing, my lord, my junior is there, the number is giving my lord, both the writ petitions can be heard analogously because in both writ petitions, I have been, my lord, but these allegations against me in all the both writ petitions. My lord, we are, my lord, this very respectable person in Bhutia community. And my lord, against us, my lord, one of the Cornell is there. All the allegations against me, and that will going to, my lord, since January, the writ petition was pending, and the next writ petition on the same allegation. Let it be taken up.
Petitioner is the same.
Yes, petitioner is the same. Allegations, representations are also identical. And all against myself and my all myself.
Totally different complaint at totally different.
No. Both the writ petition, my lord, can it be taken
So
up?
let me take up both together.
Yes,
In
my lord,
any event, we are not
analogous.
ready today.
Yes.
Let me take
My
up
lord,
both together.
Yes,
Give me
my
the number, Mr. Mukherjee.
But
please.
my junior is there, my junior is there. Vivan,
Other number.
Yeah.
Very.
well, both the my lord taken up on. I will be present physically, my lord, on 7th.
On 7th.
My lord, I will be
7th?
there.
Very well. Very well.
Mine.
Learned Counsel for the petitioner seeks accommodation. Paragraph, Learned Counsel for the private opposite parties submits that WPA, the other number, 316 of 25, 316 of 2025 pertains to a similar issue as in the present writ petition. Paragraph, let both the writ petitions appear under the same heading on 7th July 2025.
March over.
Next.
My lord, 15, my lord, may I appear on behalf of the West Bengal College Service Commission? My lord, may I take leave to appear in the virtual mode?
Yes, yes, sir.
Of course. Only Mr. Gopal Vishwas is appearing virtually. Whether petitioner is working as an assistant professor. He is
this
under
is-
suspension, my lord.
This is a service matter.
Yes.
It's no matter. It's
College education group.
Group 2 matter.
Yes. He is implicated in a case involving section
I'm
3.
little confused with group 2 and service.
But
So-
college education is group 2. ma'am.
Very good, very good.
He is implicated in a case under section 376, my lord. And prior to that also, there is a case of molestation pending against him. Molestation against a college girl, my lord, which is being investigated by the internal complaint.
Are you ready for the hearing today? So I'll take up the matter.
Not today. Mr. Gopal Vishwas is appearing on virtual. But
Not today.
Wednesday, my lord.
Wednesday, yes.
Not today takes us tomorrow. You want to make it on Wednesday?
Wednesday would be.
Very good. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on Wednesday is 2nd July.
I'm deeply offended.
Myself, Subramsi Panda, appearing on behalf of the West Bengal College Service.
Please give your name in the chat box. It will be recorded.
Yes, did you?
Next.
60 minute time for the petition. Madam, there is
Yes.
compensation appointment. Madam.
Yes.
Compensation appointment. Group 2, madam.
Have you served?
Yes, madam.
I'm for the statement.
So the husband of the petition is a guard of the college, Chamuktala College. Well, he died while he was in service. Thereafter, this petitioner is being the wife, my lord, made a
It's
representation.
appearing for the college. Have you served?
My lord, I have served. College, my lord.
Service is not complete.
My lord, only, my lord, we are to representation policy.
Maybe, but service has to be. Item dispatched, item bagged. That's not service. We have to complete and come back. Friday?
Right.
Well, every Monday we have to take instructions from Calcutta.
He's asking for disposal of the representation. Why do you need instructions?
Representation, that is definitely.
I have a good mind to dispose it of. Because if I'm not going into merits, that will not affect the
No,
the university, isn't it?
My lord, page 22, my lord. And thereafter, page 23, my lord.
This is on 6th and this is on one in November, one in December.
December.
Let these be disposed of.
yes.
Within 2 weeks.
Well, the college will be the one disposing of.
Yes, but is 2 weeks sufficient? That is what I'm thinking.
4 weeks, sir.
Let it be 4 weeks. Affidavit of service. It appears that service upon the 5th and 6th opposite parties is not complete. Stop. Nevertheless, comma, this court is of the view that since the innocuous prayer of the petitioner is for consideration of the representations submitted by her before the said opposite parties, comma, the matter may be disposed of even in their absence. Stop. The said opposite parties shall not be prejudiced by an order directing expeditious directing disposal of the representations. Stop. It appears, paragraph. It appears that the petitioner submitted representations before the concerned authority on 28th November 2023 and 6th December 2023, seeking appointment on compassionate ground since her husband passed away since her husband died in Hans, passed away together, he died in Hans. Paragraph, who will dispose of the principal?
Yes, respondent number 6, principal, Samuktala.
Please do the correction of principal spelling. I'll give you liberty. Should be PAL, right? Because I'll be directing him to dispose of. I'll grant you liberty to correct. Paragraph. Opposite party number 6 is directed to consider and dispose of the representations submitted by the petitioner within 4 weeks from the date of communication of the order, upon granting reasonable opportunity of hearing to all concerned, comma, in accordance with law.
Definitely.
Writ petition disposed of. Since no affidavit is invited, I just said my website. Ekdom shuru pe, on prayer of the petitioner, liberty is granted to correct the cause title of the application. Next.
I beg to appear for the petitioner. The petitioner, along with the private respondents, are the owners of a plot of land. The respondent number 8.
Service complete.
Teacher in charge of a high school, just trying to grab my plot of land. I have made representation, and there is a direction to the BLLR also for the spot verification and disposal. That has not been done.
Who is appearing at you, sir?
My lord, I am appearing for the respondent number 7, 8, and 9.
A school authority.
School operation, my lord. My lord, I seek the liberty to file a affidavit proposition.
Not necessary, sir. Make your submissions.
Because there are two facts that need to
Let
Your representation is for the authority.
Our representation before also the police, as also before the BLLR. There is a direction upon the BLLR also.
Conduct the spot verification.
Where is that direction?
Well, page number 22.
Who is appearing for the state? State, you're appearing?
Sub.
Page number 22.
22. That has not been done also.
This pertains to which representation, which application?
There is an order, page number 21.
This is by the executive magistrate.
To the BLLRO as also the officer in charge of the police station.
Completed, but he says it is not
No
completed.
copy has been given, and on the last occasion they have submitted.
No, it should have been in his presence.
My lord.
He says he was not there. Spot verification should be in presence of the parties, isn't it?
Yes, my lord.
Was that done? Yes, what was that done? The spot
My lord,
verification
spot verification was conducted.
was conducted in your
of-
presence?
In presence of the petitioner and the respondent opposite.
Do you have the report, the field note? Yes, notice was issued, but was the verification done in their presence?
Let that be disposed of at least. Let there be a spot verification and a recent order that be passed. Because my land is there, I am the owner of the land. My father was the owner of the land. I have also made representation to the police authorities, but at page number 29. There is a direction even on the OC in charge, but still there, since it's a land issue. And one writ petition has been filed there.
Because the executive magistrate has to deal with it first.
My lord, let that be, but the spot verification.
Some illegalities
Yes.
disclosed, then only the police comes into
My lord.
action, right?
Well, let that spot verification and the recent order be passed, because we are.
I hear that I am informed that the spot verification has been
Has
done.
been conducted.
My lord, I have
my
instruction
instruction-
that has not been done.
That's why spot verification.
Will you come back with a report? I would like to see the signatures of the petitioner also.
Well,
I want to ascertain whether it was done in their presence, right?
liberty may be given to file one supplementary affidavit. I have the photographs there also that on my land signboard has been installed.
Photographs are neither here nor there. whose land which signboard cannot make out from photograph.
Sanjay Arul
Let
School
the
Street.
report come.
My
Let the report come.
My lord, liberty to file opposition.
Then I have to file the reply. That's the problem.
If my lord allows.
Then, well,
Good.
if there's
Goes out of this circuit bench. That's good in a way. Let's come. Affidavit of service. Learned counsel for the educated learned counsel. You are
for the petition.
8 and 9. 7, 8 and 9.
8, 9.
Opposite parties number 7, 8 and 9 seeks to use an affidavit in opposition in this matter, disclosing relevant facts. Stop. Affidavit in opposition be filed within 2 weeks. Opposition.
Within 2
Affidavit
1
in
week. 1
opposition
week thereafter. Or 2 weeks.
be filed within 2 weeks from date. Stop. Affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Yes.
Paragraph, the matter be placed before the next available circuit bench.
Grateful.
Next. Huh? This one. Come on.
18 Melo time for the petitioners.
Yes.
Melo, the matters relating to compensation appointment of a college, Melo. Kindly see
Have
Melo
served?
page. Yes, sir, Melo.
Who is appearing?
I'm for statement.
Melo, main allegation is the state, Melo. Melo, kindly see page 11, Melo.
The college is represented.
Melo, college is not represented.
Have you served?
Yes, Melo, I have served.
Where is the service?
Melo, service dispatch only. Last day, 7.
Please file the affidavit of service at least.
Melo, the impugned order is passed by the state, Melo, Director of Public Instruction.
Where is
Melo,
the order?
Melo, kindly see, Melo. Melo, first, Melo, page 11, Melo. Kindly see page 11. The college authority forwarded all the paper of the petitioner, Melo, for appointment, including the inquiry report, legal hearsay certificate, school certificate, appointment letter, joining letter of the disease. And thereafter, my lord, I file a writ petition, my lord. Thereafter, my lord, the court directed to consider the asset application. And my lord, kindly see page 47. Page 47 is the High Court order to consider according with law.
Yes.
Now, my lord, the Director of Public Instructions, my lord, passed a reason order and my lord, rejected my claim on the ground, my lord. Well, kindly see page 58. Operative portion, my lord. It start, my lord, page 56, 57, 58. Is my lord, last bracket.
58, yes.
The only, my lord, the rejection, my lord, on the ground, my lord, there is no scheme for appointment of compensation appointment.
Says that there is no scheme. Yes.
My submission is that if there is no scheme, so my lord, prevailing scheme of the state government should be followed. And secondly, my lord, if the financial condition is the disease is necessary, and my lord, the income of the family member, and the court consider, and direct, my lord, to give the appointment. My lord,
This is a non-government college.
Yes, non-government college.
So how can the government be asked
My
to
lord,
pay
kindly
the-
see, my lord, similar order was passed, my lord, Honorable High Court. My lord, kindly see page 61. My lord. Here, my lord, Vidyasagar University, there is a no scheme, but the court is directed, my lord. Kindly see, my lord. Operative question page 69. last paragraph.
Give me a minute, please. I want to see if the facts are the same. Here he was an assistant professor.
Yes. And here, my lord, group D stand, my lord,
Yes.
same, my lord. And my lord, statute says, my lord, kindly see the statute of the university.
Yes, there was a direction to frame a scheme also.
And also directed at and thereafter, my lord, page 90. Another order. Start in page 72. Page 72, my lord. And operative postulate page 90.
The same issue. Yes.
Same issue. Like page 90. Kindly see page 90.
92 I've seen, yes.
Yes, ma'am. Here, my lord, card, my lord.
The same directions have been given in
Yes.
this also.
Yes, yes. And
The-
also, my lord, kindly, and my lord, page 55, 54, my lord.
In this case, I think it will be better if you serve the university also and come back.
54.
The matter needs to be dealt with on merits.
My lord, yes, my lord, kindly see page 54, my lord. The statute says, my lord.
The statute of university.
Yes, my lord, statute.
In every university, there is a different statute. Let the university covers.
No, my lord, statute, my lord, not going university is under the Kujibar College. And also, my lord, yes.
This
Non-government
college is under non-government
Non-government
university.
college.
It's the same.
My lord,
rules
kindly see
as
page
normal work.
54, 54,
I think the university, yes, I've seen.
54, my lord.
54, yes.
My lord, point number 9, my lord. 8-9. Further proviso under statute 5 of the North Bengal University state as follows. Provided that the provision relating to recruitment of non-teaching employees of affiliation college as laid down in the foregoing statute shall not apply in case where no compensation appointment on dependent of any employee dying harness is to be offered a job constitutive of his and her qualification. And on the basis of
This
that,
could be heard in presence of the college, the university. Please complete your service and come. Because this has to be dealt with on merits.
no, college is forwarded all the paper to the DI, Director of
Even
Public
6.
Instruction.
5 and 6.
Yes.
No, but still their presence is required. Since service upon Respondent numbers 5 and 6 is not complete, comma. Let the matter stand over till when can you come back? Friday after service?
Well,
Friday?
Could it be any day next week? Well, any day next week.
Tuesday?
Tuesday. Great.
8th July.
Yeah.
Under the same heading on 8th June. Next.
My lord,
I beg to appear for the statement.
I beg to appeal for the petition. One senior citizen of 75 years of age was severely beaten by the private respondent.
But have you served the
Yes,
private
yes.
opposite party?
Yes, yes.
Private response? What of who? State? You are appealing?
Yes. One complaint was lodged, FIR was drawn, but copy of FIR was not given to me. That is at page number 20.
Yes.
That senior citizen was bedridden for next 2-3 months. Thereafter, there was some recovery. And again, he was humiliated at his residence by these private respondents. And there is an attack upon him and his wife on 20th April 2025. And that gentleman committed suicide on 24th April 2025. That is the case. Here, after all these incidents, the son of that particular gentleman again and again made representation to the officer in charge, also the superintendent.
That
And
is not considered.
that has not. And lastly, my lord, the situation in which it is said that the person has committed suicide is very much suspicious. And all is written at representation page 64 to the superintendent, subdivisional police officer, and the officer in charge by the elder son of that particular person. And there is a constant threat upon the widow of that gentleman. And they are helpless because they are senior citizens. Their son is staying at Siliguri, and there's a offense is committed at Coach Behar. Let that representation be considered, and a formal FIR has been drawn up considering this death.
First, if I got it, complaint has been raised and also when charge sheet has been filed. Regarding the second, regarding the suicide lordship, first duty case was registered and after that another complaint was filed and it was also registered under section 108 and 3 of the clause 5 of BNS law. That's the amendment of public suicide.
Against?
Against my lord,
FIR named accused.
whatever they have been filed the representation on.
Let that be acted upon because on the first FIR, that is only a paperwork. Nothing has been done.
In both the matters,
Well,
it has been done.
well,
So the writ petition is. can be
Disposed of by
disposed of.
directing in accordance with law, my lord.
It has already been done in accordance with.
My lord, because
a writ court cannot
FIR
direct investigation, isn't
My-
it? It is already, the ball has been set rolling. Yes.
May I know, my lord?
Yes.
After the death, my lord, they lost the complaint after 1 month.
That the appropriate court will deal with it. Right? If they can explain the delay, well and good, otherwise they face consequences. But let the investigation proceed. The affidavit of service, paragraph heard learned counsels for the parties. Paragraph. The petitioner complains of police inaction. The first complaint was by the father of the petitioner of the
No,
first
by the petitioner number 1.
one. The first petitioner lodged a complaint
Page number 20.
before the officer in charge, Sahibganj Police Station on 7th January 2025 against the private respondents alleging respondents under several on several allegations. Learned counsel for the petitioners submits that no case was registered on the basis of the said complaint. Stop. The father of the first petitioner continued to be harassed which led to his committing suicide. Stop. The circumstances under which he committed suicide are also suspicious. Stop. The petitioners lodged another complaint before the authority on 13th June 2025, which has also not been acted upon. Paragraph. Learned Counsel for the state submits that FIR was registered pursuant to the first complaint lodged by the first petitioner and charge sheet has been submitted therein. Stop. Criminal proceeding has also been initiated on the basis of the second complaint and investigation is in progress. Paragraph. In view of the above, comma, nothing further remains to be adjudicated in the writ petition and the same is disposed of accordingly. Stop. It is expected that the investigation shall proceed in accordance with law and culminate in a final report as early as possible.
Let there a copy of FIR be given to the party. Because no if a copy of FIR has been given on the first occasion as also in the second occasion.
Copy of both the FIRs be furnished to the petitioners by the
Officer in charge.
fourth respondent,
Fourth.
by the fourth respondent at the earliest.
Grateful, man.
Huh? Huh. Yes, please do that, please do that.
Grateful.
So this direction is not required. Give him a copy. Rajiv, copy direction to give him.
I will copy the
Sure. And then I'll take the report on record, right? প্রথমে শুরুতে report submitted by the state is taken on record. একদম শুরুতে আর এই যে last direction তো take it. WPA Raj, WPA disposed of ফুলে দিয়েছে since no affidavit as it's a website. Next.
I am for the petitioner, madam.
Yes.
Matter is GST cancellation of GST registration, madam. I want to petitioner want to pay the due amount, and all the due taxes, madam, and my cancellation will be revoked, madam. One coordinate bench judgment on this issue, madam. Coordinate bench given the priority, madam. Kindly see the order, madam. That on this occasion, last occasion, honorable justice.
You are appearing?
State GST is answering respondent, madam.
The CGST is also there, so the central authority is also there.
They are informal party.
Has to be served. Has to be served. Serve and come back on Friday?
Thursday.
This Thursday? Please give this to me on the. Please give this to me on the next day. I'll see. Since respondent numbers. Three and five, right?
Yes,
Central?
3
and 5. Since service upon respondent numbers 3 and 5 is not complete, comma, let the matter stand over till Thursday's 3rd July. Next.
21, I am appearing for the petitioner. This is the matter. This is a matter relating to preemption. No, my lord, the issue is, my lord, whether the entire.
Has the larger bench decided?
No, not decided. It is, my
So
lord,
let it-
pending.
let,
Let it be out of list, lordship. This issue is still pending before the larger bench.
Learned Counsel for the petitioner submits that the issue in connection with the present matter is still pending before the Larger bench of the principal,
Honorable High Court, had
the
principal.
honorable larger bench. Paragraph in view of the above, comma, let the matter go out of list.
Grateful, Your Lordship.
Next.
Lordship, I have attended this case only yesterday. I have not received all the documents. So I am praying for. Yes, but. Please, Lordship, in 1 week's time, I'll serve and then.
There was already a direction for affidavit, for service.
Lordship, I was assigned not to this. I just like prepared not.
Very well. Learned counsel for the petitioners seeks accommodation. When will you come back? Monday. Let the matter appear under the same heading on Monday, 7 July. Please serve in the meantime, right? Next.
Yes. 23.
Petitioner?
I am for the petitioner.
Not today.
Day after tomorrow. Yeah, in that case.
Learned counsel for the opposite party. Only opposite party.
Only opposite part.
Opposite party seeks accommodation. Paragraph, let the matter appear under the same heading on 2nd July. Next.
I am appealing for the petition. The petition was directed to submit certificate, original certificate copies.
Have you filed the
Yes,
certified
that-
copy of the
that- that-
judgment? Yes.
That's sure, we did a certificate. Affidavit of service.
You are appearing for the railways?
Lordship,
Yes.
Lordship, service not complete yet.
You are
Can-
appearing.
Lordship, but service not complete.
6-7 similar matter.
Service is completed, sir. I find from the affidavit. And you are appearing. So what is the difficulty?
I am no copy over my hand.
Name tag.
Lordship,
The other ones.
I'll request you to give him another copy. Do I find that service is complete?
I don't know, 6-7 same matter.
So let there be an adjournment. He's not ready. Are you ready today?
no, sir, I have no copy. Lordship.
No.
Sir, service is complete. So please do not say that you don't have a copy. I'll request him to give you another copy. That's a different issue.
That we shall provide. Lordship,
Please,
can
please
be
do that.
next circuit.
Next circuit.
Next week.
Next circuit.
Next week.
Lordship, 24 and 25 similar matter. Yes.
Similar matter.
25.
Yeah, 24, 25 similar matter.
And these two also, 24 and 25, very. Affidavit of service. Paragraph, learned counsel, affidavit of service and certified copy of judgment filed by the petitioner are taken on record. Paragraph, learned counsel for the opposite parties seeks accommodation. Paragraph, let the matter appear under the same heading on which day? 8 July. 25, same order. You are giving your affidavit of service in 25 also? And the certified copy also, judgment? Certified copy, same order.
Grateful, Lordship.
Yes, 26. Who is appearing for the opposite party? Where is your affidavit? Learned counsel for the petitioner Petitioners seeks accommodation. Petitioners, huh? Day after tomorrow. Let the matter appear under the same heading on 8th July. Next. You wanted to use a supplementary affidavit?
Yes, my lord, I have the supplementary.
Have you served?
My lord, this is for the first time it's coming up.
Motion stage, yes.
Stage. My lord takes up the impugned order, my lord.
Twenty-seventh April.
Yes, my lord.
You are defendant number 7
I'm
before
defendant number
the.
6, my lord. I had filed an application for vacating the ex-party on that particular date. My vacating was allowed, but I could not, since it was allowed on that date itself, I could not contest the instant this application, which was filed by the plaintiff and the defendant number 5 jointly. My lord takes up my supplementary affidavit. My lord could find the petition in respect of which this order has been passed.
So there was a transfer between plaintiffs and defendant number 5.
No, there transfer was not there. This was a joint petition under order 22 rule 3. This is order 23 rule 3.
That joint
Compromise.
petition, that was rejected.
That was rejected, but however,
And that was not filed by you. You were not a party to the petition.
No, I was not a part, but I am prejudiced because my suit property is involved in is within the suit property. Now, what has happened out of the blue? This defendant number 5 had amicably settled the matter outside the court with the plaintiffs, allegedly. Now, on the basis of the my lord takes up my supplementary affidavit, my lord finds my supplementary affidavit, from wherein it would be evident that there was a compromise entered into between the plaintiffs and the defendant number 5.
Yes.
On the basis of which they filed this compromise petition seeking part decree.
So, but
that was
has been-
disallowed. The part decree was disallowed. However,
Yes.
what the learned court proceeded to do was to allow the plaintiffs and the defendant to allow the plaintiffs to execute a deed in favor of the defendant in respect of part of the suit property, and that deed has pursuant to this order has already been executed. My lord, the entire suit, there's a huge chunk of land which includes.
But it also says without prejudice to the interest of the other parties.
But my lord, pursuant to this order, what has happened? Subsequently, another order was passed. Another defendant, the defendant number 9 came up with a similar pair before the court. The plaintiffs along with the defendant number 9. My lord, is going to prejudice the entire suit. If part of the suit property is being sold in this fashion, that is my objection, my lord. Since my part of the property is already there, I am not ready for compromise. One by one, the plaintiff is trying to get the matter compromised with the other defendants. That is seriously impacting my case, my lord.
They are demarcated portions of land.
No, the entire property it was purchased from the defendants initially. Defendant number 1, 2, and 3 were the owners of the property. The remaining defendants purchased the property from the defendant numbers 1, 2, and 3. Now the suit is running ex parte against the defendant numbers 1, 2, and 3. And we are the only parties who are contesting the suit because we have purchased the property.
Yes, because they have
Now,
sold out. They
yes.
have interest.
Now
yes.
out of the blue, the plaintiff has come up and filed this suit challenging, stating that she is the actual owner of the suit property by virtue of inheritance, and that is why she is the person who is entitled to the suit property. And now she has, on the basis of this order, executed the deed in favor of the defendant number 5 in respect of the suit property.
And you say that your share is being affected?
My share is also there, my lord, within the suit property. How can it be done?
Not demarcated?
No, my share is also, my lord takes up the schedule. My lord, page number 42. This is the description of the property which has been sold pursuant to this order. Or this deed of conveyance was executed pursuant to this order between the plaintiffs and the defendant. Plaintiffs have no iota of a right in the suit property. Their right title interests are yet to be decided. And the learned court permits the plaintiffs to execute a deed in favor of the defendant by diluting the injunction that has already been granted.
If it is by and between those two parties.
Yes, my lord.
And you don't require a stay at the moment because this has been executed.
This has been executed, but the thing remains that, my lord, a similar petition has come up now before the trial court below at the instance of the plaintiffs and the defendant number 9. That is my problem because
that is not your challenge.
Not in this revisional application.
So that's a different cause of action.
That's a different cause of action altogether. But
please serve and come back. I'll admit your application. Please serve and come back.
My lord. Well, the proceedings may kindly be stayed in the meantime,
no,
because
not necessary.
Otherwise the other parties, the defendant number 9 is going to carry out the execution.
From what you have challenged here, the entire proceeding need not be stayed. Serve and come back, it will be dealt with.
It may be stayed for a limited
because period. What your point of challenge has been executed.
Yes.
Right.
Yes.
So you don't require
admitted.
Insofar as this is concerned.
Admittedly.
So proceeding did not be stayed.
Well,
that will be beyond your application.
My lord, otherwise what is going to happen is that the other defendant is going to
take necessary steps for that. That is not part of this application. We must understand, all right? Supplementary affidavit filed by the petitioner is taken on record. Paragraph, the petitioner is aggrieved by the order passed by the learned civil judge, Senior Division, Jalpaiguri, on 27th April 2023 in title suit number 44 of 2008. Stop by the said order, the learned court has permitted the plaintiffs
to effect a transfer of a portion of it.
Therein to effect transfer of a portion of the suit land in favor of the
defendant number 5.
In favor of defendant number 5 therein, pursuant to an amicable settlement arrived at between the said parties. Learned counsel for the petitioner submits that in the event portions of the suit land are transferred in a similar manner, the portions owned and occupied by the petitioner shall be affected and the suit shall become infructuous. Paragraph, it appears that the petitioner has been able to make out an arguable case. Stop, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Next circuit.
Well, that keeps it in the next week.
Next week.
Yes.
Let the matter appear under the same heading on 9th July.
Yes. Grateful.
Next. 28.
For the petitioner in item number 28, Lordship.
Yes.
Prior to going to the points of law of this case, Lordship, I am seeking your Lordship's leave to ascertain certain facts of this case, Lordship. In the year 1888, Lordship, one proprietorship firm constructed two temples at Hiralal Ghosh Street, Darjeeling, in the year 1888. Subsequently, said firm executed a registered deed of trust, and by virtue of that registered deed of trust, those two temples became the property of that trust lordship. Subsequently, price were appointed, and the present defendant number 1, who is presently serving as priced, obtained a lease from Darjeeling municipality by showing a letter as deed of gift. And after knowing that, we filed one declaration suit after obtaining the permission from the from the learned trial court lordship. Now, during the course of trial lordship, we filed an application for adducing certain evidence. I am for the plaintiff there, and here I am the petitioner lordship. By keeping that thing pending, the trial court has concluded my evidence and started for the cross-examination lordship. And if I do not place my evidences before that court lordship, I will be highly prejudiced lordship. I have also annexed my certified copy of my application and the order lordship.
Your application was filed after cross-examination of the defendant was commenced, right?
Lordship, prior to that, kindly come to page number.
You filed your application when the cross-examination of DW1 was going on.
But prior to that, Lordship, kindly come to page number 24, Lordship.
24?
24, page number 24, Lordship.
Yes.
Here, Lordship, on a specific day, I was not present. That time, that was concluded, Lordship. And on the very next date, I filed this application for adducing certain evidences, Lordship. That is kept pending.
Evidence of PW5 was closed. You've not challenged that order.
No, Lordship. But I am praying
You
that.
filed an application for reducing further evidence that was not
Lordship.
considered at all, right?
Lordship.
But when you filed the application, cross-examination of DW1 was already going on.
Lordship.
So there's nothing wrong in considering the application after completion of the cross.
Lordship.
Further evidence can be adduced at any stage,
Lordship.
right? So you can serve and come back. Let the cross continue. 18th June was the next date, so the cross is over. Cross-examination
I
of
need to seek
DW1.
instruction in this regard, Lordship, whether cross is over or not.
I'll request you to serve and come back. I don't
Lordship.
think you need a stay. Application can be considered later. also.
Lordship.
Since it had already commenced,
Lordship.
maybe the court chose to, I mean, I'm just thinking it that way. Maybe the court chose to complete the
But
cross.
during this time, if they concluded their cross lordship, then I'll face prejudice, because if
Your
I am,
application has not been turned down,
yes, Lordship, it's
right?
kept
It's
pending.
pending.
Lordship.
So serve the other side and come back.
Lordship. Till
And
then,
give
there
direction
if
for
possible,
disposal.
Lordship, till then there be a stay for only for 7
you
days,
don't require a
Lordship.
stay? No, you don't require a stay.
Lordship.
Serve immediately and come back.
Lordship.
Why do you require a stay? Let the cross continue. Why do you
Then
just all the
My
procedure?
Lord, kindly fix this matter on next Monday, Lordship.
Come back on Friday if you can serve.
By Monday, Lordship, I can serve, because
Monday, next Monday, very well. It's a very short issue, can be dealt.
Lordship.
The petitioner is aggrieved by the order passed by the learned District Judge, Darjeeling on 6th June 2025 in OC Suit 5 of 2013. Whereby the learned judge has continued with the cross-examination of DW1 without considering the application filed by the petitioner / plaintiff seeking to adduce evidence of other witnesses. Paragraph. The matter needs to be heard in presence of the opposite parties. Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. Let the matter appear under the same heading on 7 July Next Monday.
Obliged, Lordship.
Next.
29. I think 1 day accommodation also.
Not today.
Great.
Next.
Plus, item number 30, my lords, I have also filed a CAN application for condonation of delay. That has not been served yet.
Please serve.
And it's on Monday, my lords.
The petitioner is directed to serve the application under section 5 of the Limitation Act upon the opposite party and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on Monday, 7th July. Please be ready on merits also, so that I can deal with it. Next. The matter is not today, not today. Next.
32.
32, anyone? Not today.
My lord, I'm appearing for the petitioner in item number 33.
Yes.
Item number
Lordship.
32. 32, Lordship, for short possible.
Possible, not possible.
My
I'll
lord.
make it not today, be ready tomorrow.
Yes. My lord,
33.
before,
You are
yes,
appearing in 33?
33, my lord. My lord, before lordship gets into the thicks of the brief, a very small, short preliminary argument on this, my lord. Here, I have challenged what is the authority of the state GST authorities to initiate any proceeding against me, because in my humble submission, there is no cause of action on their part. Because, my lord, in civil laws, we have learned from our childhood that in order to react or act, one has to have a cause of action. Here, admittedly, my goods were being transported from Jharkhand to Meghalaya using the state of West Bengal as a corridor. And in their volumes of findings and write-ups and everywhere, they have never said that I was trying to clandestinely or surreptitiously sell those goods in the state of West Bengal. So even if I assume, do not admit, that anything is wrong, state of West Bengal under no pretext of imagination, my lord, can have the authority to try this. Because here, it's not even the CGST quantum that does matter. Here, it's a revenue neutral state as far as West Bengal is concerned. Here, what has happened, my lord, I had a shortcoming here. I must very candidly admit. I was sending a machinery for the purpose of doing some excavation work. I was renting it out to another entity in Meghalaya. Now, my lord, this was a job work to be done in Meghalaya. What my accountant did in his, I should say, inadequacy of his knowledge, my lord, what my accountant did, instead of writing delivery challan, he wrote job works challan. Of course, it should have been written delivery challan, because, my lord, here the transaction has not yet fructified. Unless I have actually leased it out, the lease does not commence. The transaction does not commence. So I cannot issue a tax invoice. I have to move the goods first, and thereafter they sign the agreements and we commence the business. Once we commence the business, then for every month, I raise a bill for rent where the tax quantum would have been reflected. But here, my lord, the delivery challan, instead of writing delivery challan, it was only written job works challan. This is the only and lonely offense that I have committed. And for that, my lord, they have taken up, seized my goods, which is still lying seized. I do not have the money to pay, my lord. That is why I could not pay the penalty amount. This is the long and short of the matter, my lord. Now, if your lordship kindly comes to page 76.
Have you replied to the affidavit in opposition?
Yes. I have given the reply. Page 76, my lord, kindly turns to.
Give me a minute, please. I do not.
My
find
lord,
it.
my lord.
When did you use your affidavit and reply? Because I do
My
not
lord,
find it on board.
affidavit in reply, my lord, I was 27th of August, 2024.
I find a compilation, but not the reply.
Reply, my lord, may I ask my learned junior to get a copy of it?
Yes, that will be better. The opposition is here. I do not find that
Yes.
like.
A copy of the reply, my lord, let me start with the matter and let my learned junior rush and get a printout of the reply. I will arrange for it. Grateful, my lord. একটু অভিজিৎকে বলে দাও যাতে তাড়াতাড়ি করে কোর্টকে বলা হয়েছে এটা এক্ষুনি লাগবে হ্যাঁ হ্যাঁ now my lord if lordship kindly comes to page 74 is the order of detention it starts from 74 relevant portion will be 76 onwards এটা কি হচ্ছে এখানে হ্যাঁ
Yes.
Yes. 74 it starts. This is the order of detention. And at 76, my lord kindly turns to. There are 1, 2, 3, 4 reasons at the top of the page 76, which lordship kindly comes from 75. Upon examination of the produced documents, it appears that number 1, excavator is being transported from Badhi, Jharkhand by NS Construction URC to BCC Buildtech Private Limited, so and so at Shillong, Meghalaya. So it's evident that it's going from Jharkhand to Meghalaya. Next, as per produced tax invoice, that is the purchase bill, NS Construction, a registered taxable person under GST holding GSTIN number so and so. This is me. I had produced the tax invoice of my purchase in just order to retain the sanctity of the situation. Reason for transportation is mentioned as for renting machine in the produced e-way bill. So everything was crystal clear. Thereafter, recipient measures BCC Buildtech Private Limited, Yamnagar, having a GSTIN number, has no declared place of business at the place of delivery of goods. I very humbly ask this question to myself. Is it the lookout of a state GST authority situated in West Bengal to see whether an entity who is registered in Haryana, Punjab, Jharkhand, anywhere, having a declared place of business in Meghalaya or not? Can they, under section 129 of the GST Act, get into all these extraneous questions? This is not a matter of investigation. This is something which is known as wayside seizure in layman's term. So it starts at provision 129, stops at provision 129, unless confiscation is done under 130. Thereafter, my lord, I proceed. Upon examination of that purchase bill or tax invoice, it is observed that NS Construction, owner of the goods, is a registered taxable person. So there is no dispute that I am registered. However, in the e-way bill and delivery challan produced at the time of interception of the vehicle, supplier of the goods name is found to be NS Construction URP. Now, my lord, let me explain what is URP. URP is unregistered person. Why unregistered person? This is the mistake that I made. In delivery challan, I have written myself as URP because in the state of Shillong, state of Meghalaya, I am an unregistered person. I am registered under the Jharkhand Act. I am not registered under the Shillong Act. It may be an irregularity. I bow down. It may be an irregularity, but it is not a criminality. It is not an illegality. And even if it is an illegality, it is for the state of the Jharkhand to call it as an illegality or state of Meghalaya to call it an illegality. They could have very well written a letter to those departments thereafter. So in the instant case, documents are prepared to cover movement of the goods by providing false information. Lo and behold, that so strong statement coming from just one observation that I have declared myself as an URP. Here, being a registered taxable person under so and so, the purported seller, that is me, is prepared document by declaring himself as an URP to evade payment of tax. I once again pause here. I fail to establish the causa causins here. How can my declaration, or rather I should say a mistaken declaration that I am an unregistered person, can affect the payment of tax? When I have purchased it, I have paid the tax. Once my transaction fructifies, I am bound to pay the tax. In the middle, in the between, there is no tax consequence at all. How can they simply say that this is done to evade the payment of tax? Thereafter, therefore, considering, and more so, the tax will be payable either in Jharkhand or in Meghalaya, never in West Bengal. Therefore, considering the above facts appears that the instant movement of the machine thing is given, the specification JCB excavator is being camouflaged to give an appearance for renting machine to simply taxable outward supply and conceal such taxable transaction to evade payment of tax. Therefore, considering the above facts, it appears that this excavator loaded on the intercepted vehicle so-and-so have been actually supplied by RTP of Jharkhand to some undisclosed recipient by using name and GSTIN of RTP Haryana as a recipient, and that purported supplier so-and-so of Jharkhand is merely supplying delivery challan and generates e-way bill by providing false information, declaring himself as an URP to cover the instant transaction as well as conceal the identity of the party, thereby allowing him to evade payment of due tax. My lord, I will pause here for a moment. This paragraph does not make any sense to me. I do not know whether my knowledge of English is inadequate or not, but this halts a few pots and pans, but it fails to establish where is the factum of evasion. I am reading it once again with your lordship's kind permission, because this happens to be the pivotal allegation against me. Therefore, considering the above facts, it appears that one excavator loaded on the intercepted vehicle have been actually supplied by a RTP of Jharkhand. RTP means registered taxable person of Jharkhand. That is me. To some undisclosed recipient by using name. By using name. I pause here for a moment. Whose name did I use? And what do they exactly mean by the word using name? And GSTIN of RTP of Haryana. Where from the RTP of Haryana comes? I purchased the machine from Haryana. I have showed the tax invoice. And I have just wanted to uphold the sacrosancthood of my transaction. Thereafter, to some undisclosed recipient of Haryana as recipient, and that purported supplier NS Construction, that is me, is merely supplying delivery challan and generates e-way bill. My lord, again pausing here for a moment. How can I merely supply delivery challan? If I am generating a way bill, that means I am putting the transaction in my books. It is electronically maintained. How can I simply merely supply delivery? Merely supplying tax invoice is an offense, and that is why I have not indulged in issuing a tax invoice, because my transaction has never been fulfilled. It has never been fructified. The situs of sale, it is a deemed sale, my lord knows, and the situs of sale in Meghalaya. Unless I reach Meghalaya, unless I reach the situs of sale, the transaction is never completed. If I issue a tax invoice, then it would have been a forgery or a fraud on the GST. I did not do so. I refrained from doing it. And thereafter, they say, merely supplying so-and-so by false information, declaring himself as an URP to cover the instant transaction, as well as conceal the identity of the party, thereby allowing him to evade payment of due tax. Now, where did I conceal? Lordship kindly takes the documents that was there. Kindly come to page 61 first. This is my first consignment note. Page 61. I will show each and every facet of it. Lordship will see the number is properly given, 587. Date is given. Name, NS Construction, Barhi, Jharkhand. That is me. From Barhi, Jharkhand. Right hand side. Lordship has got it, my lord?
Yes, yes.
Grateful, my lord. Thereafter, to whom consignee's name is BCC Buildtech Private Limited, Shillong, Meghalaya. The PIN code is also there. GSTN number so-and-so, Shillong, Meghalaya. The document, states GSB hydraulic excavator. Actual weight given. Now, Lordship kindly sees at the right-hand side, to be billed at Shillong. I have not suppressed a single thing. And the last line, that's the bill number that is scheduled to be raised. So, even if I have given other documents along with this document was also there with them. What precluded them to take cognizance of this document? Then the next page, Lordship kindly sees, this is the e-way bill. I have actually had an e-way bill at the time when I was being apprehended. E-way bill number is there at the top. Thereafter, e-way bill date is also there. Page 62, my lord sees.
Yes.
And thereafter, Lordship sees place of dispatch, GSTN of the supplier. Why URP? Why URP? I know they will show this as a chink in the armor, but no. Why URP? Because I am an URP in Meghalaya. I once again submit, it might be a mistake, but it is not a criminality, it is not an offense, and no tax can be evaded by stating this. Thereafter, place of dispatch, Bari, Jharkhand, place of delivery, near Elephant Falls, Shillong, Meghalaya. That is also given. And now at the end, the transportation is being on road, the vehicle number tallies. What else can be done? Vehicle number tallies, entry date is given. So there was no scope of my tax evasion. Thereafter, my lord kindly takes the next page, page 63. Here, lordship sees I have given it as a delivery challan. This delivery challan was there and unregistered. It is stated outward for renting machine. Then this is the delivery challan. Thereafter, date of challan given, date of the date is given, state of Jharkhand, Barhi, Hazaribagh, Jharkhand. Thereafter, the value of the goods is given as per the norms of the GST authorities. And then, now lordship once again comes back to the page 76, that is the order of detention.
Yes.
My lord. Page 76, now lordship, I will once again reiterate those 4 lines. Therefore, considering the above fact, it appears that one so-and-so excavator has been actually supplied by RTP to some undisclosed recipient. My lord, does this hold water? I once again question this to myself. I put this question to myself, my lord, does this hold water? They are writing whatever it comes to their mind, my lord. Undisclosed person, and thereafter says merely supplying delivery challan and generates a e-way bill, because they cannot simply obliterate my delivery challan or obliterate my e-way bill. They cannot undo it. And thereafter, declaring himself as an URP to cover the instant transaction as well as conceal the identity of the party. I am saying to whom I am sending it. I am locating it precisely where it is to be sent. So these do not hold water. Now, lordship kindly comes to page 87. I will not trouble your lordship with much, but kindly come to page 87, which starts from page 985. This is the order of penalty.
Yes.
My lord. Hello. Reply to Eshe. Very good. My lord, page 85. This is the same Deputy Commissioner of State Tax who had apprehended me is passing this order. Here he has reproduced the waybills content. On the next page, he is once again writing down whatever had been given to him. And then the last paragraph at page 86. The proper officer felt the need for further examination of the documents and physical examination of the goods loaded in the intercepted vehicle. Accordingly, the statement of the driver was recorded in form so-and-so, order of physical verification was given and drawn. Acha, this is very important. Order of physical verification given. My lord, I have also annexed the order of physical verification. Lordship kindly takes the physical verification order, which is at page 66.
Yes.
Yes. This is the order for physical verification. Why? What is it? What is being given? In the middle, my lord, they have written the reasoning. Tendered the documents mentioned in the annexure GST MOV 01 for verification. Upon verification of the goods and documents tendered, the undersigned is of the opinion that the inspection of the goods under the movement is required to be done in accordance with provisions of subsection 3 of section 68 of the State Goods and Services Tax Act. Read with the Central Goods and Services Tax Act. UTGST does not apply here. Or under section 20 of the IGST for the following reasons. Number 1, prima facie the documents tendered are found to be defective. I do not know why. Genuineness of the goods in transit and or tendered documents require further verification. So this is clear. They are proceeding under State GST Act, read with Central GST Act and IGST Act. In a transaction where it originates from Jharkhand, terminates at Meghalaya, neither WBGST nor CGST nor IGST in the state of West Bengal stand attracted. Had it been a sales arising out of West Bengal, then they have surely in the position to say this. And I will show your lordship, there is not a single whisper anywhere saying that I was trying to secretly sell this in the state of West Bengal. No, there was nothing. There was no whisper regarding that. Now, lordship will kindly, I'll trouble your lordship once again to page 86. I have already read page 86, now to page 87.
Yes.
On 27, my lord, page 87. On 27/11/2023, the goods loaded in the intercepted vehicle were physically verified in the presence of the driver, Sri Suresh Gupta. Upon physical verification, these are found. Whatever I have read in the detention order, my lord, it is quoted once again. Thereafter, upon examination, that purchase bill tax invoice, it is observed that NS Construction, owner of the goods, is a registered taxable person under GST file so and so. However, in the waybill and the delivery challan produced at the time of interception of the vehicle, supplier of the goods name is found to be so and so URP. So in this instant case, the documents are prepared to cover movement of goods by providing false information. Here, being a registered taxable person under GST file so and so, the purported supplier is prepared document by declaring himself an URP to evade payment of tax. Now, even if for a moment I admit that whatever they are submitting has some ground to make submission, then also my humble question is, very well, there is an evasion of tax or a chance of evasion of tax. Whose tax? Of which state? Is it the tax of state of West Bengal? No. Then state of West Bengal has nothing to do with here. They can write a letter to Meghalaya or Jharkhand stating their observations that this should have been done. You kindly take the matter up. But that has not been done thereafter. Now, therefore, considering the above fact, it appears that the instant movement of one JCB is being camouflaged to give an appearance for renting machine to a simply taxable outward supply and conceal such taxable. So they are coming into this conclusion only because I have mistakenly written myself as an URP dealer, and that mistake is also, my lord, very viable. An accountant from Bokaro, Barhi, Hazaribagh, he thinks that since his company is not registered in Shillong and the sale is taking place in Shillong, I will declare myself as an URP in Shillong. That is what he did. My lord, it may be mistaken, but it is certainly not a crime, or it is certainly not in order to evade payment of. And how can he evade payment of tax? The moment he bills him, once the rent becomes payable, there is no denying, because I have shown the tax invoice. I have shown in my purchase that I have purchased this machinery. I cannot deny the tax liability thereafter. Hence, one excavator being transported without the cover, once again, they reiterate the provisions and rules of WBGST, CGST, IGST, which has no implication in the state of West Bengal in this transaction. Therefore, the movement of this is held to be in contravention of the provisions of so and so. In view of the above discrepancies, above mentioned goods are required to be detained for further proceedings. In view of above discrepancies, the above mentioned goods are required to be thereafter, lordship kindly turns the page. It goes on for the calculation of the penalty proceeding. And thereafter, lordship, at page 89, this is also very important. Lordship kindly sees what they have recorded in my submission, what I have said. A, that's Sri Yogeshwar Shau, proprietor of NS Construction, have obtained so and so carrying on business of supplier for leasing or rental services, machinery and equipment with or without operator for providing service so and so. That on this, he has received a work from BCC Buildtech Private Limited of Haryana for supply of excavator machine on rental basis for rupees so and so, wide work order number so and so, delivery to its site in East Khashi Hill, which is engaged in the supply of general so and so. Then C, that accordingly he has purchased a new JCB. Tax invoice has also been shown for rupees so and so. The invoice is also reflected online at GST at 2A. So my lord kindly sees GST at 2A, my GST at 2A already reflects the purchase of that vehicle. So I couldn't have avoided the payment of tax thereafter. That the insurance policy is in the name of NS Construction, proprietor Yogeshwar Shau, is issued by the company, digital insurance policy number so and so, to substantiate the ownership of the machine. He enclosed sanctioned letter from Axis Bank so and so, that after obtaining purchase the machine and as per the works order of BCC Bill Take, he has booked a trailer from Jharkhand, which is the same trailer, my lord, which is going thereafter. That since the above movement was for the reasons other than supply, only e-way bill was generated and delivery challan was provided. Thereafter, my lord, kindly turns the page. I'm just outlining that in delivery challan or e-way bill, due to clerical error of GSTIN, paragraph G, due to clerical error of GSTIN of the supplier was mentioned as URP. GSTN of the recipient was also mentioned in the e-way bill since work order was received from BCC Bill Take. That as per their submission chronologically, it can be traced that there is only clerical error in generation of way bill. However, there was no intention to evade payment of tax. That's a submission. Thereafter, the department's contention that the instant movement is being camouflaged in appearance of renting machine to simply outward taxable supply and conceal such transaction to evade payment of tax is not correct and completely wrong, since I have a tax invoice issued by Premchand Motors, Ranchi so and so, financed by the Axis Bank. The invoice is also reflected in the GSTR 2A. Also, if I had made an outward supply, I would have the input of GST, which can be utilized for payment for the taxes on outward supply. Therefore, there would be GST liability on my profit element in such supply. There is no reason to camouflage the renting machine transaction as an outward supply. Now, Lordship, why I read this? These are my submissions. Let us see how they have been dealt in the ordering portion. In response to the submission, in the instant case, the driver of the conveyance is not in possession of invoice or proper delivery challan as it is signed by one Umesh Jadov as authorized signatory NS Construction. Lordship kindly sees now. Here unfolds the third case. Here where they are trying to make up a third case at the penalty proceeding stage. Upon verification of the registration of so and so, Jogeshwar Shah is the only declared authorized signatory of the concern. Therefore, the document of delivery challan produced by the driver of the vehicle at the time of interception cannot be considered. My lord, I once again pause here for a moment. It is ridiculous. It is laughable. Once I produced the delivery challan and once I established its sanctity, now they say it was produced by your driver, who does not have any authority to represent you. Hence, I will not accept it. The wolf will eat the lamb, whether it is himself or his mother. So here, my lord, the driver being a driver is not being treated as an authorized representative. Now, I will pause here for a moment and take your lordships back once again to page 64. From where their proceedings started. This is the first notice given by the GST authorities, page 64. GST MOV 01, Lordship kindly sees, whose statement has been recorded against me, statement of Sri Umesh Kumar Jadov, the driver.
Yes.
Who they refuse to accept as my authorized signatory. So if they refuse to accept Mr. Umesh Jadov as my authorized signatory, then they should not have served any of the notices on him. Then I will plead that I have the whole proceeding is done against the back of mine. They cannot approbate and reprobate, my lord. If they say that it is the driver that is your authorized signatory when it comes to serving you with notices, then they have to accept the driver as the authorized signatory when it comes my part to submit my documents. Then the next page, lordship sees page 64. Thereafter, page 66. To whom is this addressed? To Umesh Kumar Jadov, the driver.
Yes.
Thereafter, lordship kindly takes the order. Page 74, the order of detention, which I just now verily relied upon.
Yes.
In the matter of Umesh Kumar Jadov, driver of the said conveyance, at the top. Thereafter, the penalty notice, the penalty order, where they are saying that I do not accept Umesh Kumar Jadov as the person's employee concerned. In the matter of vehicle number, now they have shifted their stance. In the matter of vehicle number, now Umesh Kumar Jadov is only shown as a driver. Can lordship see? He is only shown as the driver. And in the matter of vehicle number so and so. My lord, my humble submission, this is something of a targeted and motivated action, my lord, against me. They have changed their stance from the very word go. In MOV1, it is the driver. MOV2, the driver. MOV4, the driver. All on a sudden, in the penalty order, they come, they see, they can understand that they cannot refute my documents. So all on a sudden, they say, I will not accept your document since it was tendered by somebody who had no power of authority, who had no power of attorney, who was not authorized. Now, then, Lordship will kindly come to page 90 once again. I'm troubling your Lordship with nitty-gritties, I know, but unfortunately, I cannot make out my case without this, my lord. Grateful, my lord. Page 90. Jogeshwar Shah is the only declared authorized signatory of the concern. Thereafter, therefore, the document delivery challan produced by the driver of the vehicle at the time of interception of the vehicle cannot be considered as a valid document to cover the transportation of JCB machine, as it does not contain all the particulars as prescribed under 55.
So the authority is not questioning the authority of the driver.
Here,
They're on
my
the
lord,
documents, not on the driver.
yes, what they say produce just the line
They
at the
don't
top, my
deny
lord.
that the driver is your authorized signatory.
But my lord, they're writing that Jogeshwar Shah is the only declared authorized signatory on the very line. In the instant case, the driver of the conveyance is not in possession of so and so, as it is signed by one Sri Umesh Jadhav as authorized signatory. That is why they are not accepting.
Very well.
My lord, that is why they are not accepting. Then, Lordship will kindly come to page 116 straight away.
100?
116, that is the order of appeal. It will start at page 111, it starts from.
Yes.
And at 115, the observation, the appellant, my lord, somewhere in the middle, there is a bold word as observations. Has my lord got it?
116?
115, my lord, 115. From the middle, observations.
Yes, yes.
Yes. The appellate authority has carefully gone through the facts of the case and detailed submissions made by the appellant in the appeal memorandum, as well as the documented evidences produced, so and so. The appellant submits that the appellant Jogeshwar Shah, business capacity so and so, machinery providing so and so, received a work order so and so, accordingly purchased. My lord, all these things he has already narrated. Even in the penalty order, I said, but they were never dealt with. Thereafter, one copy of the delivery challan bearing so and so number is being transported to so and so at Elephant Falls, Shillong, declared value so and so. One copy of e-way bill bearing serial number so and so, URP at 7:47 p.m. time. The details are given. Thereafter, at page 116. I will skip the first two paragraphs and come to this appellate authority finds.
Yes.
This appellate authority finds that the appellant, namely Jogeshwar Shah, is a registered taxable person in the state of Jharkhand, having GSTIN number so and so, carrying on the business of supplying services by providing construction machinery on rental basis under the trade name so and so. In the present case, goods or excavator were being transported on the impugned vehicle under a delivery challan bearing number so and so, issued by so and so, considering e-way bill bearing serial number this, generated by this, wherein the supplier is mentioned as URP and the recipient is mentioned as so and so. As per provisions laid down under Rule 55 of the WBGST CGST rules, when goods are transported without invoice and for reasons other than by way of supply of such goods, a delivery challan is required to be accompanied with the goods in the movement. Actually, my lord, Rule 55 says that if it is not by way of sale, then a delivery challan will be there. And that is what it was. In present case, the movement of the excavator machine is not in pursuance with the supply of goods, but is a supply of service under WBGST CGST Act 2017. Here I join issue. It is, of course, a movement of goods in pursuance with the supply of service, not of goods. I am at one, but not in terms of WBGST CGST. This is in terms of Jharkhand Goods Sales Tax, Goods and Services Tax Act, read with IGST. It is never CGST, WBGST. How can it be? Because they have never said that I was trying to sell it in the land of West Bengal. No, never for a single time, not even in their opposition thereafter. Accordingly, a delivery challan is required to be issued for the purpose. As for sub-rule 3 of Rule 55, where the goods are being transported on a delivery challan in lieu of tax invoice, the same shall be declared as specified under Rule 138. As regards the transaction of the excavator, it is found that in spite of being registered taxable person, the consignor has generated e-way as URP. The delivery challan is also not found not issued in accordance with rule WBGST CGST. Furthermore, closer scrutiny of the delivery challan itself reveals that it does not bear the signature of the consignor, or it's the authorized signatory who is Jogeshwar Shau, only as is evident from the registration details of the consignor NS Construction. The delivery challan produced has been signed by Umesh Jadhav, who appears to be the driver of the in charge of the impugned vehicle and not the authorized signatory of the consignor. Absence of the signature of the consignor or its authorized signatory, absence of GSTIN of the consignor, in spite of being a registered taxable person, the delivery challan admitted definitely raises question on the authenticity of the documents so produced. Hence, it was rightly denied by the. So now, my lord, the whole story has come to a different turn. First, it was being stated that why have you written yourself as an URP? Now they understood in the middle of the argument that this will not hold water. They will not be able to prove anything by saying that it is an URP. Why have I said URP? I have said it by way of mistake. It is already reflecting in my GST at 2A, 3B everywhere. So now they change their stance. They say, why will I accept this document? This is not signed by either you or your authorized signatory. Your driver cannot be your authorized signatory. That is what now they say. Now, my lord kindly notices the approbation and reprobation here. My driver is not my authorized signatory when it comes in terms of documents. But when it comes in terms of CGST issuing me notices to appear, to say, give reasons, then the driver becomes the perfect authorized signatory for me. If they are allowed, they should be stopped from taking this plea. They cannot. They are approbating, reprobating. Either you say he is not my authorized signatory, then you do the proceedings de novo, because then I have not received a single notice. Or you say he is my authorized signatory, stick to your lone wolf, that is URP point, that you have not declared yourself as a registered person, although you are registered. Yes, that is a mistake. I candidly confess that is a mistake, but that is a mistake, not something culpable under the Act. Thereafter, Lordship kindly comes to the next page, page 170. In view of the findings, the document furnished in the name of the delivery challan cannot be held proper and valid to cover the movement of goods in question. Section 129 allows retention of goods and conveyance. So thereafter, the section 129 kicks in. Since the language of the statute casts no liability to establish mens rea, it is wholly unnecessary to ascertain whether such violation was a willful or deliberate. So. Here comes another twist. Now, all on a sudden, they are on the point that we are not getting into mens rea. Till now, there was no discussion on mens rea. I had been canvassing aloud and study that I have no intention to commit this. There is no effect of committal on my side. Now, all on a sudden, they are remembering of the doctrine that revenue taxation statutes do not need mens rea. But alas, they have gone wrong once again here, because the Honorable Division Bench of the Calcutta High Court, in one of my matters only, my lord, where it was a pleasure for myself to appear, had completely and thunderously they have decided that no, it is not the question of mens rea, but the provision 129 subsection 4 cannot be rendered ocious. Lordship kindly take section 129 once. They have, I would like my learned junior to hand over the GST book if it's not there with your Lordship.
State GST,
State GST or duty CGST, anything will do. The provisions are the same. may I take your lordship to
Yes,
129 simpliciter? Yes, yes,
Yes.
yes. Because this is the fulcrum, my lord, from where the power flows. This is the pivot. Detention, seizure, and release of goods and conveyance in transit, notwithstanding anything contained in this act, where any person transports any goods or stores any goods while they are in transit in contravention of the provisions of this act or rules made thereunder, all such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released on ABC. Now, my lord, pausing here for a moment. Lordship kindly sees the wordings of the statute. It says, notwithstanding anything contained in this act, any person transporting goods in contravention of the provisions of this act or rules made thereunder. So the power to seize is given under this act for the contravention of this act. Even if I have contravened the provision of Jharkhand General Sales Goods and Services Tax Act, not WBGST. And CGST, they are not CGST authorities. They are the SGST authorities, WBGST authorities thereafter. So this is the fulcrum. This fulcrum does not give them transcendental power to get anywhere and everywhere thereafter. ABC, my lord, I am not reading because that will not be essential. It is the conditions of release. Now, provided that after C, two small lines are written.
Yes.
Provided that no such goods or conveyance shall be detained or seized without serving an order of detention or seizure on the person transporting the goods. Thereafter, the provisions of subsection 6 of 67, my lord, I'm skipping it. Provision subsection 3 and 4 will be important. The proper officer detaining or seizing goods or conveyance shall issue a notice specifying the tax and penalty payable and thereafter pass an order of payment of tax and penalty. 4. No tax, interest or penalty shall be determined under subsection 3 without giving the person concerned an opportunity of being heard. Now, this opportunity of being heard becomes ocious if you say that I will not get into your merits, I will not get into your submission. As it fell from Honorable Justice Devanshu Boshak in that matter, Asian Switchgear, it was said that a driver may die behind the vehicle, behind the wheels of the vehicle. And for that reason, the waybill may get expired. But it has to be noticed, it has to be administered properly. The reason has to be seen, whether it is a semblance of reason or it is a sham of a reason. That administrative discretion should be there. So now, here, my lord, I will show another thing. As I have already emphasized that I have given the e-way bill, that means I generated the e-way bill. After generating the e-way bill, I also showed that GSTR 2A shows the purchase of that goods. So I can never evade, I can never suppress, I cannot simply forget, I cannot make the world forget that I have purchased that machinery. It is there in my GSTR 2A. And since it is there in my GSTR 2A, the moment it fetches me any revenue, I have to show it in 3B and get it offsetted. Because whatever I have purchased, it's of huge value. The tax quantum is huge, which I paid out there. I need to adjust that. If I do not show my sales, how will I adjust? Because I have already paid it. So the question of tax evasion is only a childhood asked. There is no question of tax evasion. There is no culpability. There is no possibility. There is no possibility. It is humanly impossible to evade payment of tax here. Thereafter, Lordship kindly comes to their opposition. Yes.
Yes.
Yes. Page 3, it will be very pertinent, my lord, and unfortunate as well. at page 3 in the opposition, the revenue chose to quote the orders of penalty. I do not know what purpose that will serve. Page 3, paragraph 7, that in reference with the submissions made in paragraph so and so, also shown as URP when the petitioner was registered. A, in the instant case, the driver of the conveyance was not in possession of the invoice or proper delivery challan as it is signed by one Sri Umesh Jadhav. This is the first contention that they take as authorized signatory, who is the driver of the vehicle. Upon verification of the registration, Jogeshwar Shah is the only declared authorized signatory. It is speaking at tune with the penalty order. Therefore, the documentary evidence delivery challan produced by the driver of the vehicle at the time of interception of the vehicle cannot be considered as a valid document to cover the transportation of so and so, as prescribed under the rule. The said delivery challan is not signed by the consignor of or his or her authorized representative. It was signed by some other person. Who is this some other person? This some other person is that driver whom you have used as a courier against me. Then, when there is any document deficiency, then consequences laid out in section 129 will immediately flow, which provides for detention, seizure, or release of goods and conveyance in transit. So there is a document deficiency for a consignment note, consignment of a goods going from Maharashtra to Delhi. The officials from Ever Vigilant State of West Bengal will run and issue summons. I'm afraid that is not the provision of section 129. Here, the only mistake or the only misfortune that this gentleman had was to cross the state of West Bengal. That was the only misfortune that this gentleman had. If he was not crossing the state of West Bengal, all these cooked up fantastic things wouldn't have come up against him. My lord, it is only a sheer fact. Yes, I admit there has been a small mistake. This person concerned thought he is an URP, that is, he is an unregistered person in Meghalaya. So the delivery challan will also show it is an unregistered person. That is a mistake he has committed. And of course, this is something, if that raises their eyebrow, then they can very well go and inform it to the concerned department, and they can say that kindly take note of this. You can do it in scrutiny, in section 73 proceedings, whatever investigation you need to make. But that investigating authority should be the state authority of Jharkhand or Meghalaya. Surely not the state of West Bengal. Then my lord, they have cited the sections. I do not know how to defend that. Sections, I cannot say I deny and dispute the section. Section 68. Government may require so and so. This is understanding of the drafter. And thereafter, page 5. In the instant case, taxable goods were being transported without the cover of document. Here, an e-way-bill was generated, construction URP, and the movement was not supported by the proper delivery challan. So they are not accepting it as a proper delivery challan. Why? Because the word URP was there. This is the reason number 1. And furthermore, being a registered taxable person, the purported supplier, so and so, prepared document by declaring himself as an URP to evade payment of tax. So this is the second reason, that since I have described myself as an URP, that is enough to show that there is a chance of evading of tax. Although in my very limited understanding, my lord, I do not know how it can be coalesced, how it can be linked with one the other. Then, lordship kindly sees, again in page 6, they have chosen to quote the section. I should not say anything on that, 6 and 7. They have quoted section. I would request my learned friend not to quote sections in the opposition, because that's not exactly what it's done. Page 9. This provision clearly lays down that goods and conveyance liable to be detained if there is no contravention of the provisions of this act or rules made thereunder in transit. In this instant case, it is clear that the provisions of rule so and so, SGST rules, were clearly violated. No. Then again, the same thing. The driver is not in possession of the proper invoice or delivery challan. And thereafter, lordship will kindly come to it's basically a repetition. Page 13 will be relevant.
Yes.
Yes, madam. Upon examination of the purchase bill or tax invoice, it was observed that Ines Construction is registered in so and so, However, in the e-way bill produced at the time of interception, supplier's goods name is URP. So in this instant case, the documents were prepared to cover the movement of goods by providing false information. Here being a registered, acha. Pausing here for a moment, my lord, where from did they get that tax invoice? They got that tax invoice with the consignment itself. So who sent it? I sent it. If I was trying to evade the tax, of course, I wouldn't have packed the tax invoice as well with them so that they can get this and use it against me. That you are a, in fact, they would not be able to understand that I am a registered dealer unless they have seen that tax invoice. So of course, it's a genuine bona fide human error on my part. Thereafter, therefore, considering the above facts, appears that the instant movement of the goods excavator being camouflaged to give an appearance for renting machine to a simply taxable outward supply and conceal such taxable transaction to evade payment of tax. So such a crisp consideration. Therefore, considering the above facts, it appears that this hydraulic excavator intercepted vehicle has been actually supplied by the RTP of Jharkhand to some undisclosed recipient by using name and GSTIN of RTP of Haryana as a recipient, was merely supplying delivery charges. Lord, I do not understand what is the nature of their allegation. If they are saying that I am sending it from Jharkhand to Haryana, then West Bengal wouldn't have featured in the map. And Haryana is the, I have not even gotten it from Haryana. It is the principal company who is sitting in the Haryana, upon whose bidding I am sending it to Meghalaya. So of course there is no Haryana in this. Now,
have you annexed that document to your petition?
everything. I have annexed
The
everything.
request
Which
from
document?
Haryana?
Yes. My lord will kindly see at my lord will kindly take page 71. This is the one that I was trying to show your lordship at that point of time. It slipped. This is the physical verification. I hereby declare that physical verification of the goods and conveyance mentioned above conducted by me in my presence, and I accept that the contents recorded in this report are true and correct. Who is signing this? Signature of the owner or person in charge, given to Umesh Kumar Jadhav. So here, for all material purposes, they are treating him as my agent. And thereafter, again at page 72, lordship will see this is the worksheet where the physical verification is done. Physically, goods is checked in the presence of Mr. Umesh Kumar Jadhav, the driver of the above mentioned goods vehicle. Umesh Kumar Jadhav signs, the STO signs.
No, this is a different, I am on a different point.
My
You
lord.
say that on request of Haryana,
Yes.
you are sending it from Jharkhand to Meghalaya, right?
Yes.
So where is that request from the initiation?
Acha. Lordship will kindly take my page 61. That is the, your lordship wants the purchase order. Probably there is.
The
I will
request from Haryana, not your purchase. Your purchase is not in
No,
dispute.
the purchase order in the sense, the purchase order for the service of the rent, the rent that is for which it is going for the excavation
Yes,
machinery.
yes.
That is what lordship kindly comes at page 52. This is the purchase order, like which purchase never fructified, or rather which sale never fructified, because they are still having the custody of my vehicle. Page 52, to NS construction, Digawar post so and so. Lordship has got it.
Yes.
Annexure P2. Issued by BCC Private Limited, Buildtech Private Limited, Haryana, Jamnagar, Haryana. Lordship kindly sees the whole thing is given. We are pleased to place our work order for the supply of excavator machine with hydraulic breaker as follows.
Yes.
So this is the thing. And thereafter on the next page, Lordship kindly sees the purchase invoice. Lordship kindly sees. This is upon receipt of this, I had made a purchase. My lord kindly takes note of the date. On page 52, I received the purchase order on 19th of November, 2023. And at page 53, I purchased the vehicle pursuant to that purchase order. 22nd of November, 2023, right-hand side, top. This is my original invoice. And
Yes.
thereafter,
Yeah.
of course, the machine's policy and all the instructions are there. These were all there at the time of interception. Everything was there.
That's all your submission.
My lord, now I will go to my reply. I will ask my learned friend to give the reply to your lordship.
Yes, it was not filed earlier. The original copy is here, coming today.
Original? My lord, that's a Xerox probably, lordship. Kindly sees. In a bond paper, I have given a
Original.
Xerox in the bond paper.
It's a photostat copy.
It is
Very-
scanned.
very-
It's a scanned copy, my lord.
Very well, very well.
Yes. Now. আমার কপিটা কোথায়? না, this one. Now, lordship will kindly come to paragraph 2. I will just sum up in my reply, my lord. Paragraph 6, page 2, paragraph 6.
Yes.
The first thing that I would like to point out is the respondent in their opposition at paragraph 10 had accepted. What they have accepted, the goods were being transported from Barhi, that is Hazaribagh, Jharkhand, to Meghalaya. Second, the goods were being transported by virtue of an e-way bill, delivery challan, consignment note, and the source, that is purchase invoice. And thirdly, the vehicle and the goods were detained and penalty was imposed only due to the fact that e-way bill so generated mistakenly showed the person as an unregistered person instead of a registered person. My lord, should I tally it from their paragraph 10?
Not necessary.
Very well. Sure. So these are the 3 things that they have admitted already. Now, I say, my lord, that once they have admitted that these 3 facts, the state of West Bengal has no further jurisdiction in this. Now, at page 4, I have contentiously written the respondent at paragraph C, page 4. I'm not getting into the contents of paragraph B because here I have stated how it is beyond their jurisdiction. Page 3 and page 4, I'm skipping. Page 4, last paragraph, the respondents, I say, should be debarred from making out any third case at this juncture, as they have often tried out in the recent past, which will be clearly established on the following chronology. Paragraph, page 5. In the order of penalty, reason for detention and imposition of penalty is labeled as the petitioner has wrongly declared itself to be unregistered instead of being a registered person. Then again in the appellate order, my lord, the reasoning changed to the petitioner allegedly contravened Rule 55, since the delivery challan was not purportedly in order. While the appellate authority accepted generating URP e-way bill was an unintentional mistake, as he had upheld in the order of adjudication only the count of delivery challan being faulty. And then in the opposition, my lord, a newer stance was taken that the sending the goods to Haryana from Jharkhand, which is not at all the case. This is a newest stand in the opposition. Lordship will kindly take the next page. So this and paragraph D says mistakenly generated and the minor defects crept into the delivery challan, that too exactly where it was all vividly explained. Achha, lordship will kindly take one thing that is annexed with my this writ petition. This is the online payment of this. Eta ki annex korecho? No, lordship, that's not important. That's not important. That's the stamp duty that has been paid. Anyway. The moreover, cogent reason as to the revenue has categorically stated that the delivery challan will not be accepted since the same was neither signed by the consignor, that is to say the petitioner, nor by any of his agent. On the other hand, they have accepted that the driver had signed the consignment note. It has been repeatedly pleaded in the writ petitions at paragraph so and so that the driver is the agent of the petitioner and his signature will be enough for compliance of Rule 55 of the said rules. Once the respondents have treated the driver to be the agent of the petitioner and issued the physical verification notice, detention order, show cause notice for penalty, and even the penalty notice for the purpose of accepting documents, they cannot now say that the driver is not the agent of the petitioner. So, my lord, I have also put this on oath. This is my submission. And once again, I reiterate that they have never said that I have made a clandestine sale. So I will pause here for the moment, my lord, unless your lordships have some query on this.
No, that's fine for now.
My lord.
Yes, let me hear the authority.
Yes, my lord, I'll ask my learned friend to say it in the mic so I can hear.
He'll not be able to hear you.
Yes.
Well, at first, I would like to draw your lordship attention to section 138.
I would like to
rule
first
138.
hear your response on the locus.
Well, as they have, there is no tribunal at the present moment, my lord, and hence they can file the writ, my lord.
No, not on that. How are you, what locus standard do you have?
But that's what I was showing the law, my lord. That's why I was showing the law, my lord. Section
Yes.
138.
138?
Rule 138 of the GST. It's the same, my lord. The GST rule.
I have the state.
Yes, my lord.
Act.
My lord.
Yes, rule 138.
Now, if your lordship sees, my lord, it says every registered person who causes movement of goods of consignment value exceeding 50,000 rupees in relation to a supply or for reason other than supply or duty inward supply from an unregistered person shall, before commencement of such movement, furnish information relating to the said good as specified in Part A of Form GST EWB01 electronically on the common portal, along with such other information as may be required on the common portal, and a unique number will be generated on the said portal. So before any person is going to supply any goods, they are supposed to generate a e-way bill, and that's a mandatory provision of law.
The supply should initiate from West Bengal.
No, it's not says so, my lord. It
This
says
is-
because GST is one nation, one tax.
Because the form number is of West Bengal.
Form number?
You say that every supply from Jharkhand also has a West Bengal number?
My lord, it is a common portal in which they have to. I'll come to that also, my lord. Why it can be intervened, my lord. I'll come to that provision also. Now, having said so, my lord, 138A, my lord. 138A. Now, 138 has gone, 138A.
Yes.
Yes. Now, it says the person in charge of conveyance shall carry the invoice or bill of supply or delivery challan, as the case may be, and a copy of the e-way bill in physical form or the e-way bill number in electronic form or mapped to a radio frequency identification device embedded on the conveyance in such a manner as may be notified by the commissioner. So this is the provision of law which they are supposed to comply. The driver should be carrying a e-way bill or a delivery challan and a tax invoice. It is mandatory. It has to be. Now, my lord. 138B, my lord.
Yes.
Now it says the commissioner or an officer empowered by him in this behalf may authorize the proper officer to intercept any conveyance to verify the e-way bill in physical or electronic form for all interstate and intrastate movement of goods, my lord.
So this state is state of West Bengal.
Yes, my lord. They were doing an interstate.
Interstate is from West Bengal to any other state.
I'm
And
coming to that.
intrastate is within West Bengal.
Might be, my lord. This provision of law gives them ample power to check and verify whether they were carrying a proper e-way bill, whether it was accompanied with a tax invoice or a delivery challan. Now, the question which arises over here
It is still not clear that.
My lord, I'm saying, my lord, I'm coming to the facts, my lord. So, now, my lord, I would like to draw your lordship attention to page number 62 of their writ application, which is the e-way bill.
Yes.
There is no such provision, my lord, that that the Bengal government or the UP government cannot intercept a vehicle, my lord. They can easily intercept as per 138B, my lord, which I have shown, my lord. for verification of the document and conveyance. They have the power in case of an interstate or intrastate movement of goods.
Here the state is West Bengal.
Yes, my lord, it was being moved.
Okay, carry on.
My lord, my lord. Now, what has happened, my lord? If your lordship sees, my lord, they have declared themselves as an URP, unregistered person, even being a registered person, and not single declaration. In the e-way bill also, they have declared themselves as an URP. In the delivery challan also, they have declared themselves as an URP, unregistered person. Now, my lord, yes, and what they have done, my lord, this sort of declaration has been purposely done in order to evade tax. Why, my lord? Now, if a person is supplying something, my lord, through the e-way bill, its identity can be found from where the supply is being done, because when a ITC or anything is being claimed, my lord, the supply of goods plays a very important role, my lord. Now, my lord, over here, by declaring an URP, unregistered person, they are purposely trying to evade the tax by not paying to the government, my lord.
Evade which tax?
Evade, my lord, my lord, by not making the payment to the government. By,
Because
for
at
example,
the time of purchase,
absolutely, I'm coming, my
you
lord.
have the
because-
CGST number.
My lord, what has happened?
So
if
there
they
was
are,
no evasion at
No.
the purchase.
my lord, now they are
Point.
selling, now if they might be selling the goods, we do not know what they were doing, my lord. They might be selling the goods, they might be giving it on hire, my lord. Even if it is given on hire, my lord, it must be covered by a document, my lord, showing that yes, even in case of a service or a hire, my lord, the GST is required to be paid in such cases, my lord. It was not covered with any document. From their prima facie, from their document, my lord, it cannot be proved that there was no intention of evasion of tax. Moreover, my lord, if there is a violation of 138A, my lord, automatically the provision of 129A, 129 will be attracted of the GST Act, my lord, which says that, my lord. He has already read 129, my lord. I'm reading it again, my lord. It says, notwithstanding anything contained in this act, where any person transport any goods or stores any goods while they are in transit in contravention of the provision of this act, or the rules made thereunder, or all such goods and conveyance used as a mean of transport for carrying the said goods and document relating to such goods and conveyance shall be liable to be detention or seizure, or after detention or seizure shall be released. So, my lord, there was a clear violation of 138A, my lord. Why? Because they were, firstly, my lord, they were carrying a delivery challan, my lord. That delivery challan, as per the order, my lord, he has read one paragraph that it shows that it was signed by the driver, my lord. And as per the rule 55, my lord, if anyone is not carrying, if with a tax invoice, my lord, then they have to carry a delivery challan. That's why they were carrying a delivery challan. So as per rule 55, my lord, your lordship will find, my lord, it is required to be signed by a proper authority. In this case, my lord, it was not signed by a proper authority because their delivery challan, as per the authorized signatory, is Jageshwar Shaw. So it was supposed to be signed. So it was signed by the driver. So, my lord, that did not fulfill the provision of Rule 55, firstly. Secondly, my lord, the declaration of an unregistered person clearly shows, my lord, that there was a clear intention of evasion of tax. And I am squarely covered by a judgment of our division bench, my lord. Mohammad Shamsher versus State of West Bengal, my lord, where it states, my lord,
So prior to the orders, to whom did you issue the notice?
my lord, because their delivery challan was signed by the driver and the validity, and it was an unregistered person, my lord. So we do not know who is the owner of the vehicle, of the goods, my lord.
You have admitted the CGST and the registration and the payment of tax at the inception. The documents say so.
My lord.
So you were aware of the identity of the person.
No, my lord. The declaration as per the e-way bill showed unregistered person. How can we give some other person the notice? It is to be given to the driver, my lord. And driver has some signed the delivery challan, my lord. That's why the notices were given to the driver, my lord. Later on, Jageshwar Shaw came, and my lord, he has given an application stating that I am the owner of the goods and has filed the appeal and done the necessary things which he has done, my lord. But that is how it has come, my lord. My lord, the judgment.
My lord, I will request my learned friend to give the details of the judgment so that I can also find it out.
Please provide him with a copy.
Yes, MAT 108 of 2024.
MAT 108 of 2024.
Yes.
Thank you.
Yes.
Now it says, my lord, if page number 7, my lord.
Yes.
Roman point number 2. In respect of intention to evade tax, we find that as per the e-way bill generated by the appellant, the consigner is one PC Surya Singh of Arunachal Pradesh, who is an unregistered person, whereas the delivery challan subsequently placed on record was not signed by the consigner, similar to us, and was accompanied by a release letter issued by one BG Enterprise, a registered person under the GST Act. This mismatch is not an inadvertent one, but gives opportunity to conceal the identity of the actual user, a registered person of the inward service supply, and thereby evade payment of GST on such supply. The fact of this case is similar to this, my lord. Thirdly, the e-way bill footprint is easily available to the tax authority. Hence, the name of an URP has been intentionally declared in the e-way bill with the intention to conceal the actual recipient of rental lease service of the said JCB machine by a registered person with the sole intention to evade the tax liability. Furthermore, my lord, there is a Supreme Court judgment, my lord, in a very similar circumstances, my lord. Over here, there was a e-way bill, my lord, but it expired, my lord. What was the observation of Supreme Court, my lord? My lord, I have only one copy here. May I read and give?
Yes, yes, you can do it.
My lord, it says, having considered the matter, the court wishes to confine its consideration only to the quantum of penalty, as was made clear by order dated 8 December 2022. It is not in doubt that stricto sensu, the appellant cannot shrink from its responsibility of complying with the requirement in law to generate a fresh e-way bill if for any reason the confinement has not been transported. So over here, they have made a false declaration of URP, my lord, by declaring themselves as an unregistered person, my lord. And moreover, my lord, the declaration was not only given in one place that it can be a mistake, my lord. It was purposely given in the delivery challan and also in the e-way bill. Moreover, the delivery challan was not signed by the proper person, my lord, which is also a violation of Rule 55 of the GST rules. They have violated Rule 55, 138A by making false declaration, and there is a clear case of evasion of tax, my lord, and hence 129, a proper penalty has been imposed on them, my lord. This is the judgment of give you the copy, soft copy. No.
The reference of the judgment, please.
Yes, I'll give you the soft copy.
Give me the reference. I will.
Vardhan Associates. You know.
MAT number or something like that so that I can also find it out.
It's a reported judgment.
Reported judgment.
Yes.
My lord, I don't have the copy of that.
2023 SCC online.
Acha. 2023 SCC online.
Supreme Court 1710.
1710.
That's all your submission,
my lord.
Now, I will start from the back end, my lord. The first, this judgment.
Continue with the reply at 2 p.m.
Yes, my lord.
You come back at 2 p.m.
Yes, grateful, my lord. I will.
I've heard substantially. I would like to complete this.
My lord, I will extend all the cooperation, lordship. Grateful to my lord.
এটা ফেল দুটো সময় একটা Yes. Is Learned Counsel appearing?
Yes, my lord, I'm there.
Yes.
It was a technical glitch.
I'll
Yes.
request you to confine your arguments only to law
Only
points.
only to this
Because
law
nothing
point.
on factual aspects has
True,
been
true, true,
stated.
true, true.
Yes.
My lord, I would take the course from its backwards. First, let me ponder over the Supreme Court judgment that has been handed out by my learned friend. My lord, this judgment, as far as I can see, it is a judgment where the consignees, they failed to extend the time of the waybill. So that is not at all applicable in this case. Secondly, here, the goods were getting transferred from the state of Uttar Pradesh to the state of West Bengal. And of course, state of West Bengal had plenary jurisdiction. Then also, on the contrary, whatever I can call out from this judgment, Honorable Supreme Court probably spoke in favor of the SSC. Page 9, where my learned friend had placed her reliance. Paragraph 16, I would like to show, then 17. On the point of quantum of penalty limited to which notice was issued, it was submitted from the sequence of facts. It's obvious that the conduct of the appellant does not entitle to any lenience, especially in tax matters, where the parties have to be very serious as government revenue is involved, which in turn has an effect on the very functioning of the governments, both central and state level. Having considered the matter, the court wishes to confine its consideration only to the quantum of penalty, as was made clear vide order dated so and so. It is not in doubt that stricto sensu, the appellant cannot shirk from its responsibility of complying the requirements of law to generate a fresh waybill, if for any reason the consignment had not been transported. However, viewing the factual scenario which is not disputed, that is the appellant is the owner of the consignment and was using it in connection with its contractual obligation in UP, and then having a similar contract in West Bengal and no evidence had been placed on record, that shows that consignment was to be sold or used by for any other purpose in respect of any other party. This court is persuaded to interfere. The appellant has been saddled with an amount of so and so. The law also provides for imposition of penalty. Ordinarily, we may have refrained from interfering, but because there was an waybill that was generated, and in view of the discussions made herein above, we are inclined to vary the orders passed by the High Court. In our opinion, the ends of justice would be served if the penalty amount is reduced. Now, my lord, taking paragraph 16 and taking paragraph 19 in juxtaposition, it can be seen that the penalty has been reduced. Why? Because the waybill was generated later, though not on the spot. Like, I would like to elaborate on one small point. That is, if there is no waybill or if there is no document with the hands of the driver, then a prima facie suspicion exists that you have made the document later on. Had you not been caught, then you would not have made it. So there is a prima facie satisfaction of evasion of tax. Here, there was no waybill at all. They had post-generated. There are two stages in 129. First, there is detention. Then there is verification. And the third stage is the passing of the detention order upon hearing. My lord, in the first instance, in this judgment, the petitioner failed to produce any waybill. In our case, from the very first instance, the waybill was there. The delivery challan was there. So this is how I distinguish the Honorable Supreme Court's judgment. It is actually not distinguishing. This has got no applicability here. Second, that is a very fascinating judgment that has been given by my learned friend here. Lordship kindly sees what has happened here, which goaded the Honorable Court to pass this order. I will first show the facts, because if the facts are not placed, then the law has no application, my lord, in my limited understanding. Paragraph 2, Lordship kindly takes. Page 2, Lordship kindly takes. I will read from para 6.
Yes.
Kindly look at the conduct. Officials of the BOI, that is Bureau of Investigation, North Bengal, Alipurduar, had detained a JCB machine. On inquiry, the driver of the vehicle failed to produce any document in support of the transportation of the goods loaded in the vehicle. My lord, kindly mark it. There was no document at all. Upon searching the vehicle number for e-waybill verification in the e-way officers app, so this was an investigation. where they had to find it out, fish it out. It was found that an e-way bill bearing number so and so, dated so and so, was generated by one Messrs. Onkifa Infrastructure, Abgilla Nizam Colony, near wherever Gaya, Bihar, against the transportation of the JCB loaded from Arunachal Pradesh to Bihar. As per the said way bill, one unregistered person, namely PC Suraya Singpo of Arunachal Pradesh, was sending the JCB to Onkifa Infrastructure. Now I will skip a bit. Paragraph 7, last 1, 2, 3, 4, 5, 6th line. From the 6th line from the bottom of paragraph 7. From the release letter accompanying the delivery challan, it appears it was issued in respect of release of Hyundai excavator so and so by Messrs. BG Enterprise, Arunachal Pradesh. However, e-way bill produced by the driver for transportation shows the consignor was one PC Suraya Singpo of Arunachal Pradesh, an unregistered person. Thereafter, paragraph page 4, Lordship kindly comes to.
Yes.
Arguments at the bar. What was it argued? Mr. Choraria contends that the adjudicating authority ignored the observation made by the London single judge sat over the in appeal of the said proceedings. He reiterates failure to carry delivery challan by the driver of the vehicle was an inadvertent error, and there was no intention to evade tax liability. My lord, had my case been so, I would have been thrown out of the court. I am not stating that it is an inadvertent error to carry the. I was carrying the way bill and the delivery challan. I was carrying the purchase order as well. I was carrying my original tax invoice. What else I could carry? So all these facts here, the main contention was it was a failure to carry the delivery challan, which was dubbed as an inadvertent error. This was the argument advanced by the bar, from the bar. And thereafter, Lordship kindly comes to the next page. Discussions and analysis. Paragraph 13 is very important. Hence, it is an admitted position that there were discrepancies in the way bill and the delivery challan. That is, the delivery challan subsequently submitted by the appellant does not match the e-way bill generated in favor of so and so. Noticing the aforesaid discrepancy, adjudicating authority imposed penalty. Another line I will also quote where it shows that page 7, paragraph 17, which my learned friend has already quoted. Paragraph 2, subpara 2, secondly, kindly see the reasoning. In respect of intention to evade tax, we find that as per e-way bill generated by the appellant, the consignor is one so and so, who is unregistered person, whereas the delivery challan subsequently placed on record was not signed by the consignor. My lord, here the question not signed by the consignor came only because it was subsequently delivered. Today, if I subsequently deliver a document at the time of verification, then this question might come, where was I? Why did the driver have to do it? It is a hoodwink, it is a slipshod thing, which I have done. But no, in my case, the driver himself was carrying it. It is not a subsequent development. And all these reasonings led the Honorable Division Bench to perceive what it was actually a sham transaction. But here it is not that case. From the very outset, from the very beginning, I am giving it. It is not something which I have made up once they have hauled me. I have not given a single document which is of no relevance at the time of interception itself. When it was intercepted, I was having everything that there was. I have never tried to change my stance. And the last but not the least, that is, nobody asked this question of locus standi. The Honorable Division Bench, nor the Honorable Coordinate Bench, ever had the opportunity to get into this question of jurisdiction. The question of jurisdiction has been nudged by me from the very appellate proceeding. Lordship sees in my memorandum of appeal also, I said that you do not have any jurisdiction. Unfortunately, my lord, only having a few words like the consignor resides in Arunachal, this is also a JCB machinery, this is also an URP process, does not make up fact similar, from where it can be taken cue, from where a ratio can be used. A ratio has to be juxtaposed on the context of its facts. The facts are completely non-identical here, my lord. Now, as my learned friend was pointing out another question, that as far as Rule 138 is concerned, also I saw that Lordship had asked a few pertinent questions which remained unanswered regarding 138A, the rule 138A, and the rule cannot be dehorsed section 129. Rule 138 has not taken genesis from nowhere. It has come from the power flowing of 129. 129 says it is the act itself under this act, And even 138 makes it plenarily clear, interstate or intrastate, obviously where state of West Bengal is a party. If today I'm sending something from Tamil Nadu to Anantnag at Jammu Kashmir, will the government of West Bengal go and see? No. Here what they're supposed to see, since it is crossing the Bengal checkposts, they're supposed to see whether I have documents, the document to title, or whether there is any allegation that I am selling this surreptitiously in Bengal, whereby the Bengal can suffer a loss of revenue. Not in a single instance. My learned friend now cannot improve the facts of the case by saying, we do not know whether they were scheduled to do this or not. They still have my things. They had made an onslaught of an inquiry, but nowhere they have said that I was trying to surreptitiously sell it off, or my consumer does not exist there in Meghalaya. No, everybody is there.
That's all your submission?
My lord, and I wouldn't have liked to burden your lordship by a judgment, but there is one judgment which I would like to submit before your lordship. If lordship kindly gives me the any email ID or anything, I can send it here and now. It is Asian Switchgears case where the division, it's a well-known judgment, my lord.
You have the copy?
Very well, my learned friend will come to my rescue
It's
here.
also said about mens rea, my lord. Mens rea is not
In-
required in such cases.
Yes, in copy ta dao.
You've given a copy, right? Yes, she has already given a copy. This is the same judgment? Yes, yes. Thank you.
Yes.
Yes.
So here, my lord will kindly see paragraph 36. Kindly takes paragraph 36. Subsection 3 of section, my lord, internal page number 17.
Yes, yes.
Subsection 3 of section 129 of the Act of 2017 has a requirement of issuance of notice with subsection 4 thereof, mandating the adjudicating authority not to pass an order of penalty without affording an opportunity of hearing to the defaulter. Compliance of principles of natural justice is inherent in any adjudicating proceedings unless specifically ousted by a statute. In the present case, section 129, 3 and 4 of the Act require compliance with the provisions of the principles of natural justice. My lord, may I please?
Yes, yes.
My lord. Pronouncement of an order of penalty. Requirement of compliance with the principles of justice, natural justice before passing an order of penalty ipso facto means that the adjudicating authority has the jurisdiction to evaluate the merits of defense taken and speak thereon. The mechanism provided under 129 of the Act of 2017 allows the adjudicating authority to accept the explanation given by the defaulter in given facts and circumstances and not to impose a penalty. The adjudicating authority has to consider the mitigating and aggravating circumstances after affording the defaulter an opportunity of hearing and arrive at the finding whether there was a violation requiring imposition of penalty or not. Imposition of penalty cannot be said to be automatic, given the mechanism provided for by the legislature in 129, 3 and 4 by affording an opportunity of hearing. Thereafter, the revenue had cited a few judgments where it was dealt with by the Honorable Court and said the department has been relieved of the burden of proof of mens rea or motive in respect of statute imposing penalty as a civil obligation for violating a tax regime. However, absence of requirement to establish mens rea by the department cannot be equated with an automatic imposition of penalty under the scheme of 129 of the Act of 2017 in view of the provisions of 129, 3 and 4 thereof. A delinquent alleged to have violated a tax regime inviting imposition of penalty nonetheless may have potential defenses which would require consideration by the adjudicating authority. The delinquent may have a defense of reasonable cause in non-compliance. He may have set up a defense of impossibility of performance and adherence to the tax regime leading up to the default. He may have suffered a supervening event, unforeseen and unavoidable, making the compliance with the tax regime impossible or burdensome. Such defenses set up have to be considered by the adjudicating authority. In short, the regime of imposition of penalty as envisaged under section 129 of the Act of 2017 does not automatically result in the penalty of a violation of the tax regime stipulated without the adjudicating authority alluding to and deciding on the differences, if any, set up by the passing a reasoned order thereon. Hence, my lord, here my humble submission is this, that mens rea is much a later portion of the issue. The first portion of the issue, which I have been canvassing from day one, that my dear revenue, you do not have the jurisdiction, that has neither been considered nor answered. Only eloquent silence remains as an answer, my lord. Nowhere in their orders they have stated that how they are usurping the jurisdiction. Nowhere. Only that the act says state and interstate. But that is not their cup of tea. My lord, that is
Reiteration is not required.
my lord, that is what
Already made this up.
my lord, that is what I submit. If unless there is some questions from the bench, my lord, I would rest my submission here.
I'll reserve this.
My lord, I'm grateful to my lord.
Kindly go through paragraph number 7. The facts are similar to the one.
There cannot be a reply to a reply. It will be never
My lord,
ending.
no, my lord. I know that, my lord. Just kindly go through paragraph number 7 of the judgment which I have filed, my lord. And my lord, I think I've.
Cannot hear. Kindly in the microphone, please.
Yes, that's not in dispute at all. That's settled.
So that is it only from the my side, my lord. 3-4 points. One is jurisdiction. The other is their consistently changing stance. My lord, I could not hear her.
To have retained the vehicle and to inspect the e-way and as per this order, my lord, proper officer has retained the vehicle.
Have you seen this notification dated 20th November? The jurisdiction?
Yes, my lord. It's the same act, my lord. The 138B clearly states that when there is a movement of goods interstate, like over here, it was going from Jharkhand to Meghalaya, my lord. It was an interstate movement. And so they could have retained it and I could verify the e-way. 138B clearly states so, my lord. They had ample.
I am not on their
even
detention. I am on their levying of penalty.
And yes,
They can verify, and after verification,
If
once
they
they
are
see
not-
it is an
they do
interstate
not follow the
movement,
provision of
corridor
138B,
traffic, they were
my
ought
lord.
to release it.
Are Baba. If they do not,
I'll consider
my
this.
lord. And kindly, my lord, see my division bench order, my lord, that they that was also with regard to
My lord,
our
is anything
interstate
more
movement of
given?
vehicle, my
Is-
lord.
is
This
anything-
point has not been considered by any of the benches.
My lord, and he has also
The locus.
raised this in the writ petition, so that I would have annexed those orders and everything. my lord.
Locus was not.
And he has not specifically raised this locus point in his writ petition, my lord. So
Absolutely, it
that
is raised.
I
May I
could have
may I
in the
indicate?
affidavit
May I
opposition, otherwise I
indicate?
would annex the orders.
No, may I
along with
indicate?
my EA.
My lord, the paragraphs also I will indicate, and moreover, it's a question of law which can be taken up at any point of time.
If it is a interstate, my lord, the department has every power to detain and check whether the e-way was valid.
I'll consider.
My lord.
Arguments concluded, judgment reserved.
My lord, only one thing, if lordship wants, I can show where in the petition I have pleaded excess of jurisdiction.
I'll go
May
through
I?
it.
It is there, my lord. It is there in
Not
the petition, and
necessary.
moreover, even if it is not there, it is a question of fact, my lord. A question of law, which can be taken up at any stage.
বইটা ভেতরে যাও। এখন থাক, আমাদের অন্য কিছু লাগে। এটা ভেতরে। Yes, next matter. Yes, 34.
There's a direction to file a report in the form of an affidavit.
It's appearing for the petitioner. A report, an exception, everything was called for.
Well, report I have filed.
There's no one appearing. Miss Madhusri Datta, she's not there.
It was.
Not today. Please give it to me tomorrow.
Lordship.
Not today. Normally they will list it. Normally they will list it. Next. Yes. Have you served? Yes. You have filed a report. When did you file the report? The exception is there.
It was filed probably in the first week of March.
No, I do not find it on board. Do you have a copy?
Well, kindly take it up tomorrow, I shall come with copy of the report.
Oh. You want to come back on 9th? So you want to 9th, very well. By consent of the parties, comma, let the matter appear under the same heading on 9th July. You don't want to proceed? Learned counsel for the petitioners submits that the petitioners do not intend to proceed with the matter any further. Paragraph in view of the above, the application is dismissed for non-prosecution. There shall, however, be no order as to costs as a certified offset. Next. Yes. Anyone in 37?
I'm for the district questions.
Yes. Service was not complete on the earlier date. You have completed. Who is appearing for the state?
I'm for the district question.
You're appearing for Jilla Parishad also?
No, Lordship, only
Jilla Parishad is a different
Yes,
representation. Have
Jilla
you
Parishad is
served?
the answering respondent, Lordship.
Where is the service on Jilla Parishad? This is state. I do not find. Because they are the answering respondents,
Yes,
right?
Lordship.
District magistrate, DLLRO. I do not find Jilla Parishad's C. Yes.
Yes.
Prabhadipati.
Respondent number 6. 8, Lordship, respondent number 8, and the 6.
Panchayat Samiti also. They'll be represented separately. The state will not represent the Panchayat.
Yes.
Panchayat, you're for?
I led by him, Lordship.
State. So you have to serve the Panchayat, the Jilla Parishad separately. Please, please. Lincoln. It's only the state that you've served. Next week? Is it a short matter?
How much of the land has been acquired for fighting the franchise?
Come back next week after service. Let me deal with the matter.
Let them appear.
Yes, absolutely.
Great, my lord.
Since service upon the 6th and 8th respondents is not complete, comma, let the matter stand over till Tuesday, 8th July. Through the affidavit of service. Next. Yes,
30,
Mr. Ghosh.
30, is it 380? My lord, 380? 380 or WPA 380?
380.
Yes.
Yes.
My lord, I am for the, here is the responding authority.
If you let,
Yes.
take
My
the
lord.
last two orders, where there was a direction upon the Provident Fund authorities to file a report. Now, my lord, the crux of the, my lord, the writ petition is, my lord, that for a particular period of time, when admittedly, the administration, management and control of this tea garden was with two joint receivers, special officers appointed by this honorable court back in 1980s for about 21 years. During that period, Millard, so far as the Provident Fund dues are concerned, Millard, without any basis, subsequently by an order of this honorable court, when the management of the garden was handed over to me, they initiated 20 to 25 cases, which has been mentioned in Annexure P11. Now, Millard, relying upon Bhajanlal, Millard, we prayed for stay of all those proceedings, Millard, until and unless it is decided on merits in this writ petition as to whether liability for that period can be fastened upon me. Millard would kindly recall 17B of the Provident Funds Act, when transfer of undertakings happen and when liabilities get transferred to a new transferee. So, Millard, in light of that, Millard, this honorable court on two occasions, Justice Bhattacharya called for a report
Yes,
from
a
the
report
Provident
was
Fund
yes.
authorities. And his lordship was minded to stay all the proceedings, but subsequently
no,
the
that
matter
is
could
not.
not be taken up.
That is not.
Yes, are you ready with your report?
Lordship, I, so far as the Darjeeling is concerned, Lordship, there is a.
Where is your report, sir?
Officer is transferred. No, so far as per my instruction, Lordship, they kindly come to the page number 159. Kindly, page number 159. In writ petition, annexure P13. Lordship, get it?
Yes.
P13, 159. This is actually the information to the notice to the establishment. This case is pending before the learned CGM Darjeeling. That has been information. So so far their dues, so far the dues,
the report?
so far the dues that has been the case has been initiated before the criminal case. So, my lord, there is a pending for 1999. Lordship.
Where is
I
the
have
report, sir?
Lordship,
Very
kindly
simple
give me
question.
because of the there.
Last chance has already been granted and no further chance will be granted.
Lordship, kindly give me 1 week's.
I will, but I'll stay this in the meantime.
Lordship,
Extremely
kindly give me one.
Millard, these proceedings, Millard, requires to be
Lordship,
said. I
because
tell you,
of-
Lordship, why? Millard, kindly seize the amount. 500, 400 rupees,
So-
1 CR case.
Lordship,
Every day, Millard, my management is being heckled by a warrant of arrest.
Lordship, that
For all 35
this
cases.
notice that at all that has been pending the case. That's why information, not they are taking any action against them. Because of there is a criminal case has been pending, Lordship.
Millard, let them
Lord,
come with a report,
Yes, there
whatever
are
they want.
35 criminal cases pending.
Yes, CGM Darjeeling.
Yes.
And they appeared and they some of they were warrant issue, I think. So far I can come to learn. Their warrant has been issued
That
because
is
of
the
that.
difficulty.
Because
Whenever
of-
a new manager is joining,
Warrant
he's
has been
heckled with
issued.
20 warrants.
So these pending
The
cases.
the functioning of the
Yes,
garden.
no. This is where pending cases. This is the information for of the pending cases. Lordship, so far they are
What is your prayer in the writ petition?
report
Kindly
is
take the prayer.
this notice.
Please, sir.
Yes.
Millard takes prayer B, that the petitioners have no responsibility or liability to make payment of any provident fund contribution
either on account of the employer share for the year 1996 to 1999 until 9th October 2003. When Millard admittedly the garden was under the management of the special officers and Millard C, he also did. Criminal cases.
This is their, C is the main pair.
Yes.
Because this is the case, this is for only information. They are giving no steps have been taken against it. Nothing has been disclosed in this notice. So far, the dues is pertains to the year 1999.
So for this period, whether the liability can be fastened upon me, that is subject matter of the merits that can be adjudicated. For the time being, let the proceedings be stayed.
Year 17B is very much clear, Lordship.
Let there be no coercive steps taken against the petitioner.
Yes, Lordship, we are not taking any coercive, Lordship, because of there is the information. Lordship, kindly, there is a letter is information.
All the more you're not prejudiced.
Lordship.
If you're actually not taking any coercive steps, you're not prejudiced by it at all.
So far, warrant is pending in judicial magistrate is concerned.
It's being called for by this court from February 2025.
Lordship, I agree. Lordship,
Last chance for several dates
Lordship,
over.
kindly.
See, if your authority is not in a position to submit a report,
Lordship, kindly
the
give me one.
petitioners are entitled to some relief.
I mean, 1 week. Or Monday is a fixed Lordship.
I'll give you more time.
Lordship.
Next circuit, it will be
Grateful. Lordship,
coercive
Lordship,
action.
because of the warrant has been pending, that is not pertains to this notice, Lordship. Pertains to the criminal case.
No coercive steps
Lordship.
with regard to these 35 cases.
Extremely
That's
good.
the
Millard
subject
can.
of this
Millard,
writ petition, right?
as far as
Lordship,
Bhajanlal's
Lordship,
lecture is
Lordship.
concerned.
But if you are so anxious, you should have been ready with your report today.
Lordship, so far my difficulties is concerned, Lordship, the officer all are transferred.
That is not
only
the
on the Lordship.
court.
Lordship, I have talked with, immediately Siliguri has been command. Lordship, kindly give me one week. Kindly give me
I'll
one
give
week,
you
Lordship.
time.
Lordship,
I'll give you more time, don't worry.
Lordship, give me 1 week, Lordship. Because of the notice is not also coercive taking in it.
The authority has failed to submit the report as called for, as sought, despite being given several opportunities, including a last chance for submission of the report. Paragraph Learned Counsel for the Provident Fund Authority seeks further accommodation to submit the report. Paragraph, such accommodation is granted. Paragraph, the matter be placed before the next available circuit bench. Paragraph, no coercive steps be taken against the petitioners in connection with the criminal proceedings stated in the notice issued by the authority on 16th July 2019 till the matter is taken up by the appropriate bench.
Grateful, extremely grateful.
Grateful.
Next. Yes.
Well, this application is not maintainable here, my lord.
Who is appearing for the petitioner?
My advocate record is Meena Shabnam.
Mr. Gopal Roy for the petitioner, is he there?
On the last occasion, he prayed for time.
He prayed for a short time and you prayed for a longer time. That's recorded.
And I'm with the instructions, my lord,
You are for the state?
for the bank, my lord.
Who is
On the-
appearing for the state? There are private, no, these are all Bandhan Bank, right?
My lord.
Customer service.
Yes,
aid,
grievances
etc.
against the bank, my lord.
Who is appearing for the, but state, they are respondents. There is no service upon the state also.
State আছে ইন্সপেক্টর আছে, ইন্সপেক্টর ইনচার্জ, অফিসার ইনচার্জ, না ইন্সপেক্টর ইনচার্জ হবে। Our officer in charge, highway. crime.
This is RBI. None appears for the petitioner next circuit. I do not find anyone. None appears for the petitioner, no accommodation is sought, the matter be placed before the next available circuit bench.
His
Next.
relief rise before you, other forum, not here. His account has been debit freeze, my lord. Pursuant to instruction from the Bengal police station, my lord, which is out of the jurisdiction of this.
I do not find anyone, so let the other bench decide.
Let it be next week then, my lord, if he comes. Because
The petitioner has to be there. Let us see if he comes and mentions, I'll consider.
my lord.
My lord, item 40, I'm praying for this circuit.
Next circuit. On prayer of the, in the last circuit also you prayed for this circuit.
This is-
It is wrong, madam.
Mr. Shukra Prakash Nair will appear in this matter.
Not relevant.
General transfer matter.
In the earlier circuit, it was this circuit. Now this circuit, you say the next circuit. Please don't continue with this. On prayer of the petitioner, the matter be placed before the next available circuit bench. Next. Yes. Served?
Lordship, in this matter, I'm appearing for the Ram Panchayat. There was a direction to file affidavit.
Yes.
Our affidavit is ready, Lordship. Kindly give 2 days time. In the meantime, I will file the affidavit. Kindly take it up day after tomorrow.
A report in the form of affidavit was called for, right? It's only the panchayat.
Yes. I'm for the, not I'm for the state, but my lord, Pradhan is answering this. Answering with.
Pradhan is the answer.
It's not a.
Can you serve an advance copy because he may need to come back with the
Tomorrow.
reply. So I'll fix it day after.
Yes.
The learned counsel for your respondent number.
Five. Number 5 is.
What, Jila Parishad is not a necessary party. So why have you implemented him?
Actually, upon them.
If you have implemented the Jila Parishad, you have to serve.
I have served.
You have served the Jila Parishad?
Service, everybody's service, already I have service. That is in record. Everyone is served.
Learned counsel for the fifth respondent seeks accommodation. Paragraph, let the matter appear under the same heading on day after is 2nd July. Next. 42.
My lord, I'm appearing for the petition at 42. My lord.
Yes, 42.
Lordship, here the matter entails a rectification in my GSTR form 1. That is my return. The question has already been answered in affirmative by the Honorable Supreme Court in one of the matters, but in another matter, the Honorable Supreme Court had appointed Mr. Arvind Datar as the amicus curiae, and the Supreme Court wanted to hear something from him. So on that issue, in the last occasion also, this matter was adjourned. And thereafter, Lordship knows Honorable Supreme Court is in the leave right now. The vacation is going on. It will reopen on 14th. As far as my instruction, my information goes, my Lord, it will be taken up somewhere in the last week of the month of July. Lordship kindly takes the last order passed, page 2 onwards. Page 2 onwards will speak for itself.
Order dated 3/4/2020.
Bridge Systems Limited.
Bridge Systems Limited. Here, Mr. Datar has been given the mantle of the amicus curiae, my lord, to assist the court.
Let the matter be out of list for the time being, right?
My lord. Let the matter come back in the next circuit, my lord.
Let
Probably
it be out of list. You can mention once it is disposed of.
Very well. Very
Why encumber the list
very well, lord.
unnecessarily,
Very
right?
well. Very well.
In view of the observation made by this court in the order passed on 3rd April 2025, comma, let the matter go out of list for the time being.
Madam,
Next.
I'm grateful to my lord.
Yes, 43.
43 and 44. Both are similar kind of matters, one where report was called for.
A report was called for,
Yeah.
but I do not find the petitioner. Mr. Debayan Goswami. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. 44. Anyone in 44, the petitioner?
Same petition.
Same order. Rajib, next circuit. Next. 45.
Worship 45 and 46, similar matter. More two matters I have mentioned today. Let the matter taken up tomorrow altogether.
Very well, very well.
46.
What is 45 and 46?
45 and 46.
You have served?
Yes, all every service
In all
there,
the-
there
in
is
all
a
the matters?
direction for filing report.
What is the issue?
That is Mahatma Gandhi engineer project, the one supply done, payment has not been yet done, made and
Manegra project, my lord?
Manrega, yes.
we have not uploaded our bills in the portal. That is the issue.
The Manegra project has been closed by the central government, my lord, and they have not made Union of India a party to it, to their writ petition, my lord.
Oh.
They are the necessary party, my lord.
That
There is
why
a
I'm
direction
seeking
passed
all
by.
the matter together so that I can take leave and implement Union of India party.
Let all four appear together. All right.
Look.
Please give the numbers of the other two. I need to take them up together. Please give the numbers. চারটে ম্যাটার একসাথে কালকে এই দুটো নট টুডে করুন এই চারটে পর পর রাখুন কালকে 45 and 46 are same you said and two other matters are there, right? I'll take up all four together.
951, 952, 953, 953.
বুঝিস না 951 952 আজকে আসবে 953 954 mentioning আছে yes 47.
My lord, is there any written
No.
No, I've just made it not today, so please come back tomorrow. Yes, this is 47. What happened?
For the state.
Petitioner? None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. 48. Petitioner? 48. No one.
And for the state.
Same order. Next up. 49.
Lordship, Land and Council Mr. Suraj Bhattacharya is
Item
appearing
number
virtually.
49, I am for the petitioner. My lord,
Yes.
uh,
Have you served?
my lord,
appealing for the
affidavit of service has been filed earlier.
Yes,
We
yes.
have intimated.
The state is appearing. Yes, please make
Oh.
your submissions. What about the private? There is a private respondent, I find. There are, yes. Have you served the private respondents?
Yes, my lord. Previous occasion, we have served private respondents. Affidavit of service is on record.
Please give me a minute. It's item bagged, item dispatched, that is not service, sir.
If my lord needs, then I will make another attempt of service.
It's all item dispatched and item bagged, that is not service. Needs to be delivered. Please
My
serve
lord,
the private respondents, sir. Have you checked? It's all item bagged and delivered. Yes. Private respondents need to be served. They are not served. Because they'll be affected, I'm sure.
Yes.
Since service upon the private respondents is not complete, comma, let the matter stand over till Can you come back next week? When can you come back? Friday?
Friday, my lord.
Can you serve by Friday?
Yes, my lord. We'll start by Friday.
Friday is 4th July. Let the matter stand over till 4th July. Next.
Deeply on that.
For the statement.
Lordship, I am for the petitioner.
Yes.
Supplementary evening error thought problem.
Have you received a copy?
Yes, ma'am. My lord, in this matter, the answering respondent is the Central School Service Commission.
Yes.
Mr. Sunit Rai from Principal Bench appears in this matter. I had a talk with him. He said he has not received the copy of the brief yet.
But where is he? He should be appearing.
Yes, my lord, he was there since morning, but
I have submitted reviewed in service earlier.
he has asked my junior to take time. Not today, my lord, if my lord keeps it tomorrow.
I'll just make it
I
not.
can hand over one copy.
Please do that. I'll make it not
I am
today
giving
only.
to you.
No, not me.
How
Sunit Roy.
can I give?
I'm giving you the number, you just.
You can
set it.
mail it to him.
Yes.
Yes.
I'll just make it not today in that case, right?
Lordship.
So please give this to me tomorrow.
Lordship. Grateful.
Next.
Biplab.
Lordship, in this matter, Mr. Parthapratim Roy will be appearing physically, Lordship. Therefore, praying for time. Kindly fix it on Monday, Lordship.
Next Monday. Yes, my lordship. Monday.
Led by additional application.
Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 7th July. Next.
My lord, in item number 52, I am appearing on behalf of the respondent authorities being the Siliguri Municipal Corporation, my lord.
I'm for the statement.
Lordship, I am for the petitioner. Services not served upon the private respondent. We have filed a CAN application for adding the new address of the private respondent, Lordship.
My lord, may I suggest one thing, my lord?
Yes.
My lord, this is a very small matter where they have made representations before the Commissioner Siliguri Municipal Corporation and they had sought for prayers for considering their representation, my lord. To my humble submission before your lordship, this matter can be disposed of right now with a direction upon the Commissioner being the respondent number 4 to consider the representation within a stipulated period of time upon giving notice to all the interested parties and providing a detailed hearing to all the parties, my lord.
Yes.
My lord, will find the representations in
There are two
annexure.
representations, right?
Yes, my lord. Annexure P6, page number 27, being dated 19th of November 2024, and annexure P7, being page number 30, which is dated 5th of March 2025.
But in that case also, I think the private respondent has to be served. Could you serve?
Yes, Lordship, but it's written back with Indro's address late. So we have filed today the CAN application for adding a new.
Where is your application? You file it today.
So kindly fix the matter on Friday, Lordship.
A very short matter. No, the can be disposed of. Day after?
Yep.
Have you served copy to the others, to the other respondents?
No, Lordship, today.
Please do that. Please do that in course of this day, right?
Okay, Lordship.
My lord, in that event, my lord, one indulgence before your lordship. Let the matter be in the next week because of my medical purposes of my father, I will be little bit busy and will not be able to attend, my lord.
Very well, next Monday.
Monday, my lord, Monday.
Learned counsel for the petitioner seeks accommodation. Petitioners seeks accommodation. Learned counsel submits that an application being can 1 of 2025 has been filed. The application is not in the file. The department is directed to put up the application along with the file on the adjourned date. The petitioners are directed to petitioners are directed to serve copy of the application upon the respondents. In the meantime, upon learned counsels appearing for the respondents. Let it be served with the counsels. Upon learned counsels appearing for the respondents. In the meantime, paragraph, let the matter appear under the same heading on Monday, 7 July. 7 July. Grateful.
Deeply obliged, my lord.
Next.
54, but similar matter was fixed on 7. 53 and also 54, both similar matter, madam, in the morning, similar matter fixed on 7th, madam. 7th? Kindly fixed on 7th.
Service is not complete.
7th, madam. They also
Still not complete.
No, madam.
Yes,
Similar
we received the brief, my lord. We need instruction. Kindly keep it on 7th.
7th, madam. Similar matter
issue, my lord.
Similar issue, only one matter will be disposed.
You are appearing for all the respondents.
Yes, my lord. State. Here only the state response are there.
By consent of the parties, let the matter appear under the same heading on 7th. 7 July. By consent of the parties. 53 and 54, same order.
Madam.
Next.
My lord,
For the petitioner, I'm paying for next circuit in this matter.
On prayer of the petitioner, the matter be placed before the next available circuit bench. Next.
And for the petitioner, lordship, for lordship.
It's a hearing matter.
Yes.
That is what is recorded.
Yes.
Who is appearing for the state? Mr. Rahman is appearing.
Mr. Rahman is the state. Not lordship.
Hearing matter analysis,
Lordship.
Have you exchanged affidavits?
No, there was no such direction. There was by an order dated lordship, 18 January 2021, there was a direction upon the state to conduct an inspection. And thereafter the inspection report was to DSO.
Report was filed, my lord, on 3rd of August 2020.
I'm going to copy them.
আমি কাছে কপি নেই, বিক্রম ফাইল করছি। What I find from the this is actually changed with one of the
for me also.
I
The
do
matter
not
is
have a copy of the report also.
I think the report is here.
I need to take a
Yes.
copy of the report.
There is a report.
To me to copy the copy नहीं तो होगा चाहिए. No, may I indicate your lordship? No.
This order gives a detailed note
Yes,
of.
yes.
Let me just go through the.
Yes, yes, lordship.
Yes.
This is a alleged violation of an
Yes.
status quo order. That's the crux.
Status quo order, and there was the direction upon the police authorities that considering the allegation that despite the order of the court, a construction is going on, let the OC Bagdogra PS be directed to see that the order of the court is not violated and the order of status quo is obeyed by both the parties. Now,
That has been done, my lord, subsequently.
in spite of passing of these orders, I made presentation
That was
to both the
subsequently
police,
carried out.
concerned police stations as well as the commissionerate.
That was
Still,
done.
they went on with the
A private respondent is involved.
yes, private.
Have you served?
Yes, the election, they were there.
There are a lot of private respondents.
Yes.
More than one. 11 private respondents.
Mr. Shantuki Basu appeared for respondent number 11.
11, yes. So that indicates that others were served, right?
Yes, others were served.
And there were directions for affidavits also.
Well, they have filed my report in the form affidavit way back.
No, may I indicate?
2020.
After passing this order by the civil court, still they went on with the construction. And I made complaints before the police commissioner as well as the concerned police station. Nothing to my aid. Then I filed a writ petition. The order of the earlier round of litigation is at page 99. Lordship.
Yes.
Yes.
So representation was considered after
Yes,
that, right?
subsequently it was considered, but your lordship, I have challenged that order, challenged by the consideration order. So what has been stated here, and you see, there was a direction to see that no construction takes place and the order of the learned court, civil court is complied with. What they stated that they have stated that they have filed FIR. If filing of FIR is not an issue, they have to see that no such construction takes place.
So that has already been stopped. It's in my report. That has already been, now the status quo is being maintained, and my lord takes up my the result order, my lord, at page 103 of the writ petition.
I'm getting report, report.
My lord takes up the second page, that is page 104. A specific case has been drawn up on the basis of the complaint against the accused person. That case ended in a charge sheet. Now the case is pending for final disposal before the concerned learned ACGM court, Siliguri.
But my concern is whether the order of the learned civil court has been.
Obviously, it was
No,
complied.
no.
And
Still-
that allegation,
still that
my lord,
one.
if I may say, he has the option to take recourse to order 39 rule 2A if there has been a violation of the injunction. And any violation of the injunction has
Kindly come to the last
has to
portion
be
of the
taken
order.
under order.
Kindly come to the
39
last
rule 2A.
portion of the order.
There
Sir,
has to be
as
there
per
is a
law,
specific
police
provision of
action
the
has been taken for implementation of the order to the learned civil court.
This is not even a final order. This is an interlocutory order passed by the learned court in
When there's a direction, when there's a direction upon the police are bound to comply that. They're bound to
We
follow
have
that.
already complied. Now the petitioner wants us to hand over possession to him.
No. We have never said that. We have never said that. First of all, when this order was passed, there was no opportunity
Yes,
of
they
hearing.
have found a construction. They have taken legal steps against that.
Lordship.
And I have implemented the order. I've just seen the order. The OC was directed to see that the order is not violated and order of status quo obeyed by both the parties.
That was done.
But my instruction is still that the construction was going on.
No, not at all. There's nothing on record to show that presently after that steps have been taken by the police, construction work is going on. Nothing on record. He's just submitting verbally. There's no supplementary affidavit to that effect.
Kindly give us a copy of your report. You show.
They were already been served. You have
This
already been
report
served, sir.
Submitted in 2021.
You have
Now,
already been
Lordship,
served.
now what has happened at the earlier, that one on the court, he had expired. Now, the party, even the petitioner, he even did not know. Subsequently, it has come to me, Lordship. If you Lordship grants me an opportunity, I shall take a copy of that report and I shall go and I shall take instructions from my client.
Without instruction, how would you, sir?
But
You can ask for a certified copy. The
Yes,
report is with the
yes, Lordship.
It's already
records.
filed in court. Copy is also already been served. Police have already done their part, my lord. What the petitioner needs to do is to file an application under order 13 and rule 2A. Your Honor would appreciate that. My lord would appreciate that.
Because
They
prima
have not-
facie, it appears the police says that they have implemented and they are keeping vigil.
Yes.
But my instructions are otherwise. So still, they are the private respondents are
There is
carrying
no
on with them.
supplementary affidavit to that
There's no
effect.
supplementary.
No, I shall file. No, I shall take a certified copy of that report, Lordship.
Next circuit,
In the yes, Lordship.
in the meantime, it will not happen.
Yes, it will.
The petitioner seeks to obtain certified copy of the report submitted on behalf of the state. And respond to the same in accordance with law. Paragraph on prayer of the petitioner, comma, the matter be placed before the next available circuit bench.
Grateful.
Next.
My lord, I'm praying for copy.
Not today. Next.
58 not.
Yes.
Yes, Mala. Till today, I did not receive any availability in opposition.
My lord, the matter was dismissed for default. It has been restored. We pray for 1 week time for file our
1 week. Learned counsel for the
respondents.
petitioner seeks accommodation for a week.
Respondent. Petitioner.
Oh, I'm sorry, respondents. Respondents seeks accommodation for a week to use the affidavit in opposition as sought. Paragraph affidavit in opposition be filed within a week from date.
By 9th of this month.
Affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Well,
Paragraph, the matter be placed before the next available circuit bench. Next.
Grateful.
Lordship, for the petitioner, I'm led by Senior Advocate Mr. Amlesh Ray. We've been directed to file an affidavit in reply. Lordship, I humbly pray before you to grant us a week's accommodation.
Next Tuesday,
That's
yes.
grateful, Your Lordship.
Learned counsel for the petitioner seeks a week's time to use the affidavit in reply as sought. Paragraph, let the matter appear under the same heading on 8 July.
Grateful, Your Lordship.
Next.
Lot 60, I beg to appear on behalf of the respondent number 2 and 3. Lord, we have filed our affidavit in opposition and the further affidavit, but we are yet to receive any reply, Lord.
Where is your affidavit in reply? Not ready. How much time?
1 week long. So Lordship, the repairing body and the acquiring body, my lord, they are saying that acquiring body saying that we have not acquired. Repairing body saying that yes, they have acquired, but my lord, my land has gone. I have not got compensation.
To come back with an affidavit in reply in that case. Let her come back.
No objection.
Learned counsel for the petitioner seeks accommodation to use the affidavit in reply as sought. Paragraph, let the matter appear under the same heading on 9th July. Please serve advance copies.
Oh, no, sorry.
Next.
Lordship, in item number 61, I'm paying for next week, Lordship. On 88, Lordship.
No hearing matter will be taken
Lordship,
up next week.
Lord-
How can all the hearing matters go
Lordship,
to next?
Mr. Choraria will be appearing in this matter due to some personal difficulty. To come.
Where is the affidavit in opposition?
Lordship,
That's also not ready. Who is appearing for the opposite party?
Lordship, that I have no.
For the state?
That 61. 68. Choraria sir তো ছিলেন।
Mr. A. Ray, Mr. Siddiqui, Mr. D. Ghosh, Mr. Kothari. These are the 4 names that are recorded.
I think it's the CGST matter.
CGST matter, yes.
Yeah, state GST. Lordship, I'm praying for.
Affidavits are not ready, so no use keeping it next week. We will let it appear. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 10th July.
8, Lordship, he will physically come and do the matter, Lordship. 8.
How will he do the matter if the affidavits are not ready? I do not understand.
In 1 week, he will ready and serve the copy.
Without the opposition, have you received an opposition?
No.
So you'll file a reply without the opposition.
I have no instruction. 10, Lordship, 10.
10th July. You've not received copy of the opposition, right?
Lordship, Lordship.
So reply on what?
Actually, Lordship, I have no instruction
Very,
regarding.
very well. Come back on 10th, I'll consider.
I'm grateful.
Next.
62, I'm appearing for the petitioner, my lord. It's a ready matter.
The hearing matter.
Hearing matter, the hearing had once been completed, but we were, the honorable judge had asked me to file a written submission. That is also
Not
ready.
2 hearing matters a day.
Yes.
My lord, this won't take much time. This won't take
No,
much time.
please come back next week or maybe
For CGST.
My lord, this won't take much time. We are all ready. Both the sides are ready, my lord.
sir, I'm so sorry. I'm not as intelligent as you are. I'll need some time to write out a judgment.
My
So
lord,
please-
as
Please
lordship
come back after a
pleases.
couple of days at least.
My
Friday?
lord, my lord,
Friday?
very well, lordship.
By
My lord, may I submit the written submission? May I
Yes,
submit
you
that?
can
Then
if
the
you want to.
yes,
By
yes.
Friday, by Friday. And please serve an advance copy.
No,
That will
I am serving it here and now, my lord. It's ready. I have also given them so that lordship,
Very well.
the file will be
Notes of
prepared.
argument.
Yes, madam.
Notes of argument.
Mine is ready.
You can submit. You can submit. If
Yes.
you want.
Yes.
Even the petitioner is ready. You're appealing
Yes.
in CGST.
Yes, sir. We are for the CGST.
You've, I need to hear the arguments afresh actually.
Yes.
I have no idea about the matter. Do you still want to file the affidavit, the arguments today?
Yes, my lord, not an issue because I have already completed once. And I guess my learned friend is also ready with the.
Next, yes. So please come back on Friday with your
Okay,
notes.
okay. Very well, ma'am.
By
Very,
consent
very
of the parties, let the matter appear under the same heading on Friday is 4th July.
my lord, grateful.
Next. Yes.
I'm for the response of court.
Petitioner,
Soptoshi
I'm for the
Bonik.
response of
have
court,
you
my lord.
received copy of the reply?
No.
Affidavit in reply? No. An accommodation was
We
sought
have-
on the earlier date for the reply. You are
We
appearing for the
we have
petitioner?
already
Which matter? No, I'm for the primary counsel.
You are for?
Primary Lordship, I'm for the petitioner, Lordship.
Your affidavit in reply?
I'm appearing for the petitioner. My senior, Mr. Said Mansur Ali, is appearing on behalf of the petitioner.
Very well, sir. Where is your affidavit in reply?
Lordship,
You took time on the earlier date for your reply.
Lordship, I filed a supplementary affidavit. Regarding affidavit and reply, I have to seek instructions. I kindly fix on Wednesday or Thursday. I'll be
This Thursday?
This Wednesday or Thursday.
Very well. Come back on Thursday.
Wait.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 3rd July. 3rd July.
Thank you, Lordship. Grateful.
Lordship, I'm praying for 1 day accommodation.
Not today. Not today. Next.
My lord, I appear for the petitioner. I'm praying for 1 week accommodation, my lord.
And for the
There's some gap in communication between me and the.
1 week.
1 week. my lord.
Next Tuesday.
Next Tuesday.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 8th July. Next.
I'm bringing.
66. Anyone? Direction for affidavits. No one appearing. The parties are not represented. No accommodation is sought. The matter be placed before the next available circuit bench. Next.
67.
Anyone? What is wrong, petitioners? We are for the state. Jalpaiguri, someone was appeared. Oh, no one. Affidavit in opposition was called for. Yes. Mr. Shubhashish Mishra was appearing for Jalpaiguri. Where is he? He generally appears. Next circuit. Affidavit in opposition is not filed as yet. None appears on behalf of the fourth respondent, comma, nor affidavit in opposition has been filed. Paragraph, the matter be placed before the next available circuit. Next.
My lord, I'm for the state. There was a direction to file affidavit in opposition, my lord.
Yes,
I'm
Secretary.
filing the opposition, my lord, and
Have you
I got the
served?
copy to the.
Should have served earlier.
Lordship, I'm praying for fixing this matter on Thursday. Actually, the conducting advocate is not here. He's
You want to file a reply to this? No.
liberty may be that. I will take instruction.
Affidavit in opposition filed by the state.
Yes,
State is taken on record. Paragraph, on prayer of the petitioners, comma, liberty is granted to use a reply to the affidavit. Paragraph, let the matter appear under the same heading on 9th July.
my lord, one indulgence, my lord. Let one line be recorded that I have handed over the copy to the petitioner.
Please, because
In before the court.
his prayer I've recorded, so that
But-
indicates that you, sir. Next.
69, we are for the CGST department.
Lordship, in item number 69, I'm led by Mr. Amlesh Rai, Senior Advocate, Lordship. Lordship, we want to use the affidavit in reply to the oppositions filed by the
You
state and
received
the.
copy of the opposition.
Lordship,
Yes, we have already filed on 16th May. 16th
Lordship
May.
already received, Lordship.
তোমরা দাও নি? হ্যাঁ, আমরা জমা দিয়ে দিচ্ছি।
Yes, it is on.
My lord, this is a settled matter. The Honorable Supreme Court has already, in the recent judgment.
He wants to come back with a reply. Let him come back next week.
Yes.
Next week?
Next week.
Lordship, there is an interim order which is subsisting kindly.
Till 31st July.
Lordship, whichever, further order whichever is there, so.
We are still in June.
Already pending.
Moreover, matter is pending before the Honorable Supreme Court. The issue regarding they have challenged the virus of the notification. The authority has issued 3 notifications. Those 3 notifications were challenged by the petitioner. And against that challenge, several petitions were filed in different high courts. Ultimately, matter is now pending before the Honorable Supreme Court.
The same issue.
Same issue. I have the judgment.
So there's already an interim order in this matter. So let that continue. Let that continue.
Yes, yes.
I'll put it out of list in that.
Yes,
case.
yes.
Right?
Yes, ma'am.
Lordship.
That doesn't disturb you. You are safe.
But in the similar matter, Honorable Delhi High Court in a division bench order, the matter has been disposed. Keeping in
It is
view,
pending before the Supreme Court. How can I dispose it of?
yes, that That's why my humble submission, let the matter be disposed of.
How? Even if the same issue is before the Supreme Court? How can it be disposed of? It will be out of list.
Out of list, all right.
You can mention after the
Yes,
Supreme Court
yes,
deals
yes,
with the
yes,
matter,
yes.
right?
No, sure.
It is submitted on behalf of the parties that a similar issue as in the present matter is pending consideration by the Honorable Supreme Court.
Supreme Court number, SLP number,
Paragraph in view of the above.
I got the SLP number also.
Not necessary. In view of the above, comma, the matter, let the matter go out of list for the time being. Let the matter go out of list for the time being. Paragraph, the interim order granted earlier shall continue.
Worship, with the liberty to mention it.
That is already there. The law grants you the liberty. Next.
69, 70, same order. Madam.
70 also?
70.
You are the petitioner in 70?
Yes.
Very well. Vashuk,
Yes.
77.
Grateful.
71, no one. None appears for the parties. No.
I'm on behalf of the state filer. Madam, I'm seeking time for filing the activity in opposition filer.
Petitioner is not there. Very well, I'll give you time. None appears for the petitioner. No accommodation is sought. Paragraph, learned counsel for the, viewer for the?
For the state.
Learned counsel for the state seeks to use an affidavit in opposition in this matter.
There was a direction to file affidavit in opposition, my lord. I'm just extension of that. time.
Learned counsel for the state seeks extension of time to use the affidavit in opposition as directed. To use the affidavit in opposition as directed. Paragraph, affidavit in opposition be filed within 1 week.
1 week. madam.
Within 1 week from date. Stop affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench.
Break.
Next.
Lordship, I'm for the petitioner. I'm led by Mr. Ramlesh Ray, senior advocate.
Yes.
Lordship, I humbly pray for not today.
Very well, not today.
Grateful, Your Lordship.
Next.
My lord, Mr. Ghosh is appearing in this matter. He's on his leg in court number 1.
Looking for an extension of time, file the affidavit. There was a direction to file affidavit in opposition.
Not filed.
Okay, my lord,
1 week.
Instructions, my lord, that is, I have to ask them for some correction.
1 week.
No, 2 weeks will
2 weeks.
be required, madam.
2
Because
weeks.
there are many corrections required.
Where? Learned counsel for the state seeks 2 weeks accommodation to use the affidavit in opposition as sought. Paragraph, the matter be placed before the next available circuit. Next.
Yes, my lord, direction was passed to file an affidavit.
Yes. 2 weeks. 2 weeks.
Instruction that we have received, requires some 2 weeks, 2 weeks. my lord.
Sufficient, next circuit.
It's been pending.
2 weeks, 2 weeks. Same order, Vashuk. Next.
75 years, the affidavit is ready, but yet to be affirmed. If you look at, and he keeps it on Monday,
He needs to come back with a reply.
let it be Monday so that I can serve.
Learned counsel for the state seeks extension of time to use the affidavit in opposition as called for. Paragraph, affidavit in opposition, you'll file on Monday. Let the matter appear under the same heading on 7th July. Please serve an advance copy. Next.
Sir, I'm paying for Wednesday, Lordship. Day after tomorrow, Lordship.
Day after.
Yes,
For
Lordship.
the private respondent conducting approach out of school for medical treatment, father-in-law will come 9th of July. The candidate fixed on 10th of July.
Affidavits exchanged.
Yes, Lordship. So for my knowledge, Lordship.
The opposition is there. Where is your reply? Your reply?
Reply with my lord, advocate on record, Lordship. He,
It's with him.
With him, Lordship.
On prayer of both the parties, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th July
Lots of lines are given, 10th July.
or 10th July, very well. 10th July. Have you received copy of the reply?
No, I have not.
You have not, very.
My lord, I am appearing for the opposite party.
My lord, I'm praying for time. Mr. Ghosh is in.
A conciliation proceeding is going on, I believe.
Lordship, there was a.
Is it settled?
No, Lordship. No report has yet been filed, although it was, as per the submission of the mediator, it was on the verge of being settled, but subsequently the father backed out. And the matter was
No,
not.
but there should be a mediator's report in that case.
And no report
A
has
failure
been
report.
filed. No report has been filed till now, although there was a specific direction to file the report.
Mr. Bormon was appointed to act as special officer.
Yes,
He has to come back with a report in that case.
there was a direction.
Mr. Bormon, where is he?
Actual matter is pending since long and no report is being filed. And
Because there has to be a report. Matter cannot be taken up on the judicial side otherwise, isn't it?
Yes.
If there's a failure report, I can take up the matter on the judicial side. Not today.
Not
Please
today.
come back tomorrow with the necessary instructions.
Yes.
Next.
Lordship, I'm for the petitioner.
For the opposite party number 1.
Lordship, in this case, Lordship, respondent number 2 died, and thereafter I made a party. Respondent number 2, Piti Korna Sarkar died.
Lordship, can you see his order dated 14th February?
Thereafter, I made a party, Aparajita Sarkar and Aparna Sarkar.
Yes.
Previously, he appeared on behalf of the.
I appeared on behalf of opposite party number 1, but the new parties
But
were
was
added.
but not served.
Name has been added. Now they have to serve a copy of it. They have not done this.
Lordship, tomorrow I will serve with Lordship. Kindly fix the matter next week.
Next week.
Yes.
What do you want to put in?
Okay.
Who is appearing for the LIC?
I don't know.
LIC also.
We have to respond number 1.
Have you served the LIC?
Yes, Lordship. That is the previous serve and also file.
Yes, but I see Mr. Ganguly only appearing.
Lordship. He was with the on the impression that I'll represent the new parties. I don't know if they come to me.
I
They
know.
Previously.
He may subject to service.
Yes, Lordship, I will also serve the LIC also.
Please do that because I do not
okay,
find
okay, Lordship.
they have not been represented also. Since service upon the substituted opposite parties and the third opposite party is not complete, comma, let the matter stand over till next week.
Next week.
9th July.
Grateful.
79, Lordship, for the opposite party, Lordship.
Petitioner?
Lordship, Lordship, we are for the opposite party, Lordship, we are ready with the written notes of arguments. Can we kindly keep this matter?
Written notes of argument will not help. I have to hear it again. I have not heard.
Lordship, kindly keep this matter Monday, Lordship. We are ready with the written notes of arguments.
Written notes will not help, madam. You need to be ready with the argument.
Yes, Lordship.
Right.
Kindly keep this matter to Monday, Lordship.
Very well, Monday.
Grateful.
Learned counsel for the opposite party seeks accommodation. Let the matter appear under the same heading on Monday, 7th July. Next.
Item number 80, I'm praying for not today.
Not today. Have you served?
Yes, I am.
You're
My lord, I am appearing for the opposite party, my lord.
Not today only. Please
Yes.
come back tomorrow.
Right, my lord.
Next.
Kindly fix it tomorrow.
Not today.
82. I am paying for next week, Lordship.
Next week. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 10th July.
Grateful.
Next.
83.
Lordship 83, I am for the petitioner. Lordship, the pertains to the premises tenancy act. Lordship kindly fix on the Monday. It is very long.
So many matters on Monday.
Monday or.
Have you served?
Yes, they have appeared already. The matters are ready for hearing, Lordship. This is where party, is the premises tenancy act. We have the agreement, but that has been, when the suit has been preferred, we have amicably settled and Solenama has been filed. In Solenama, that has been stated in 1986 that we, Mr. Basu's client will agree that he will vacate the premises in the year 1996. In the 1996, prior to 1996, Mr. Basu's client, one of the client, took a plea and filed a suit for declaration that whatever the Solenama filed in the compromise decree, that is not been binding upon him because of he or she is minor at that occasion. In that case, 1994 of the said declaration, that has been going for 1990, in the year 1990. That has been suffered by the Mr. Basu's client. They preferred appeal. That has been suffered. Then again, another client of the Mr. Basu's prefer an appeal, suit for declaration that the decree has not been binding upon me because at the time of that decree, I was minor. That has been dismissed and they have preferred, that has been also dismissed. So that in this meantime, it will go for 2008. Thereafter, my client prefer title execution in connection with that decree, 2015. And this 2015, my execution has been turned down on the limitation because of the limitation. And there in their said limitation, my client prefer an appeal. The appeal will turn down because of you should go for a revision. And when revision has been filed, that has been also turned down because of limitation. I filed the second appeal. Second appeal, Lordship, the second appeal has been there with a specific direction that go for you have this is for a civil revision because of the order revised civil order. And that is the matter. Lordship, kindly fix on Monday or Tuesday, Lordship, kindly take it stand.
Affidavits are exchanged?
Yes. There is no
Not necessary?
No,
Not
no,
necessary.
it's a matter of
Time, but
there has been time. What is the limitation is actually condonable or not? That is been Lordship's
Prayer
consideration.
The parties, comma, let the matter appear under the same heading on Tuesday,
Lordship,
8
Lord,
July. 8
deeply locked, deep locked. Time will be taken because of so many matters. That's it.
Next. Yes, 84.
Yes, deep locked.
Petitioner,
This is my supplementary evidence of petition that was also passed.
petitioner is not there. Next circuit.
No, Lordship.
But petitioner is not interested, is not there. Whether it is simple or complex.
After tomorrow, let's have it. I do not know whether.
Sir, it is the petitioner's case. He has to be interested.
But in this matter, one status quo order was passed on the very first occasion, and thereafter, though they have not prayed for any extension, I have filed one CAN application for extension of that application. My CAN application is there. So let the matter be fixed on the after tomorrow matter. One opportunity be given.
Can you pass an or can file an application on an order passed for the petitioner? Is your application maintainable?
But status quo regarding the property.
Maybe.
Because it is the joint.
It was on prayer, it was on prayer of the petitioner, right?
Absolutely.
If the petitioner doesn't seek extension.
But order was.
This is not a cross suit that you can file a counterclaim, right? So I don't think your application is maintainable at all. Very well, if you want, I'll keep it on Friday. Let us see. A supplementary affidavit in opposition filed by the opposite parties is taken on record. None appears for paragraph, none appears for the petitioner. No accommodation is sought. Paragraph, learned counsel for the opposite parties seeks accommodation. Paragraph, let the matter appear under the same heading on
Monday.
Monday, 7 June.
Great.
85.
I'm praying for 1 day accommodation.
Not today.
Grateful.
My lord, I'm paying for 1 day accommodation on behalf of the opposite party.
Lordship, I have already.
Not today. Please come back tomorrow.
Let the affidavit.
I'm not passing an order today, so
As
please
the-
come back tomorrow.
Good.
Next.
87.
Lord, I am appealing for the petition.
Yes.
So service has been completed.
Where is your affidavit of service?
Affidavit service, my junior has gone to collect the affidavit from.
Not today.
So other service, matter may be taken as a short matter. My lord,
Short or long, you have to serve, sir.
it is served, Lord. Lordship, I will.
Shall I make it not today only? Will you come back
Lordship,
tomorrow?
Lordship, Lordship.
Sudesh Nagar Ashwin.
Yes, sir.
So the hearing matters, no one interested.